an award of monetary damage.
No, Your Honor, the test is not a magic words test, and the same is true of the abrogation of sovereign immunity. The methodological question is whether the statute is amenable to more than one plausible construction under the traditional rules of statutory interpretation. If it is, then the spending clause's clear notice principle breaks the tie in favor of the recipient. But here, Tanzan teaches us that this statute is amenable to only one plausible construction under all of the ordinary tools of statutory interpretation. That's the methodology that this court employed in Eagleson. It's the methodology that the Supreme Court employed in Richland Security Services versus Chertoff. It's the methodology that the Supreme Court deployed in FAA versus Cooper. There is no magic words requirement. The key is that all of the traditional indicia of meaning here point in the same direction, and I'm happy to walk through why that is the case.
So before you do that, Mr. Halberg, I want to ask this question to the extent you answer it together. My focus is on the spending clause as well, and I think Tanzan is a separate issue. Tanzan talks about the statutory construction and the meaning of appropriate relief, but Tanzan doesn't say anything about the authority under the spending clause and whether or not Congress, separate from the notice issue that Judge Rovner has raised, the authority of Congress to enter and pass this type of statute under the spending clause. And we addressed that in Nelson. You're relying on Sabry to say that that Congress does have that authority, but Sabry was in place before Nelson. So my question for you is, what has changed since Nelson that would clarify that or show that Congress had the authority under the spending clause to pass this statute that would impose liability on third parties?
I think it's vitally important that Nelson did not decide the constitutional question. It avoided that question.
That's true. I give you that, but the language in Nelson made pretty clear what the court thought about authority under the spending
clause. That's fair, Your Honor, but I do think the holding was an avoidance holding.
And I would agree with that, but it doesn't avoid the question of what has changed since Nelson, or what are you relying on for the authority under the spending clause?
Sure. So let me just say that Nelson's avoidance of the question was a prescient exercise in judicial humility, because in that case, the parties did not brief the necessary and proper clause. They didn't brief Sabry, and they didn't brief the many other spending clause statutes in which Congress imposes liability on non-recipients. We are now making those arguments here. The spending clause, in conjunction with the necessary and proper clause, empowers Congress to prevent employees from interfering with the execution of its spending clause conditions. That argument and that tandem of constitutional provisions was not before this court in Nelson, and that is why I say it was a prescient exercise in judicial humility for this court not to hold that Congress categorically lacks an authority that is so vital for Congress to actually ensure that its spending clause conditions are being honored and not undermined. And I think this case is case in point. Congress needs to have the authority to impose liability, because otherwise state employees, prison officials, can violate this statute with impunity. And that
is why.
So
do you think the Ninth Circuit got it wrong? Because we would be creating a circuit split with the Ninth Circuit if we agree with you.
I think that there's a way to read Wood versus Yorty to treat that as dicta, but I do think that the Ninth Circuit was incorrect. The Ninth Circuit said that the liability rules do not further RLUIPA's objectives under the spending clause. That is just manifestly, respectfully, not correct. As this case shows, and as other cases show, without a damages remedy, there is no deterrence, and the statute becomes broadly unenforceable in the prison system whenever prisoners are released or transferred.
Well, the Ninth Circuit said more than that, though. They said that they distinguished Sabry on the grounds that it involved the very federal funding, which was at issue in the statute.
That's right, but I think that the principles that Sabry articulates go beyond the bribery context, and I don't even think that's an entirely correct characterization of Sabry, because on one of the counts, the defendant in Sabry, the petitioner before the Supreme Court, was convicted of paying money to receive a certain land use permit from the government. So the only money at issue in that case was the private citizens' money, and in return they were receiving permit allowances from the government. So I don't think that is a faithful reading of Sabry.
Does it matter that that involved a public official and a private citizen, whereas here we have two private citizens?
I don't think so. If anything, I think this case is easier than Sabri because we have an employee of the funding recipient who knowingly acquiesces in RLUIPA's remedial regime when they accept employment with that funding recipient. And in that respect, RLUIPA is not unique. Congress frequently imposes liability on employees of funding recipients to ensure that its spending clause conditions are being honored and not undermined by those employees. It did that in EMTALA, the Emergency Medical Treatment and Active Labor Act, and it did that in Title X, the statute at issue in Rust versus Sullivan. Now again, I say that this court in Nelson versus Miller was prescient to exercise judicial humility and not decide the question because none of those statutes were before the court in that case. And the parties did not even brief the fundamental point about the conjunction between the spending clause and the necessary and proper clause and the way that that grants Congress the authority to ensure that employees are not undermining the substantive conditions in its statutes. And I see that I'm nearly at my rebuttal time, but if I could just make a few quick points about the statutory text. So we know that appropriate relief includes damages under Tanzan because damages are the presumptive remedy when a state official violates federal rights. And in a case like this one where it's damages or nothing, appropriate relief means damages. It doesn't mean nothing. Congress would not have used the formulation appropriate relief if it meant to create no remedy at all. And one way we know that is that Section 4 of RLUIPA authorizes the United States to seek declaratory or injunctive relief, but not damages. That suggests that appropriate relief sweeps broader and was meant to include the traditional range of remedies that are available against defendants in their individual capacity. And as Professor Laycock points out, if this were an injunction-only statute, there would have been no need to define government to include official or any person acting under color of state law, because an injunction against the institution runs necessarily against those individuals. That all would have been surplusage if this were an injunction-only statute.
Mr. Halpern, perhaps the presiding judge, Rovner, will give you a few more minutes, but I want to ask you a couple of questions.
Of course I will.
Do you find the Sixth Circuit, since you're suggesting we may have a circuit split here, do you find that similarly flawed the way the Ninth Circuit's analysis is? The Sixth Circuit finding it.
I think the Sixth Circuit's decision is flawed for a different reason. So Judge Sutton in Haight versus Thompson rightly recognized that Congress does fundamentally possess the power to impose liability against non-recipients, but he held that the statute was insufficiently clear to authorize that form of relief. But it's important to remember, Judge Sutton was writing in the shadow of the Supreme Court Sosamon decision and without the benefit of Tanzan. Tanzan changes the game. Tanzan deploys all of the tools of traditional statutory construction and teaches us that the statute has only one clear meaning. So I do think there are district courts in the Sixth Circuit that have recognized that Tanzan fundamentally abrogates Judge Sutton's reasoning, Haight versus Thompson.
Just another question, following on Judge Rovner's mention of context in connection with the Tanzan case. The case specifically speaks to the financial loss of the because of tickets and the like. Is that just factual noting by the Supreme Court, or should that have any bearing? Because we don't really have financial loss in this case, do we?
We don't, but we have dignitary harm.
No, I'm not questioning
Right.
the potential for damages. I'm just saying, so we should just disregard that reference to the actual cost.
I think that was another reason why the Supreme Court understood that damages were appropriate, because it was damages or nothing. And so here we similarly have damages or nothing because Mr. Walker has been released and there's nothing to remediate his injury other than an award of damages.
Well, his injuries here are what? Pain and suffering?
This court has recognized an independent constitutional injury for dignitary harms, and I think a violation of RLUIPA on egregious facts like these would rise to that level.
Yeah, well, how do we assess what damage potential is here? What guidelines would you have us have here?
I think unfortunately, we're not at that stage yet because we first need this court to recognize the damages remedy.
Well, I'm trying to look down the road a little bit.
I think that those are questions that juries grapple with all the time about how to quantify damages in cases that involving dignitary harms, and I think that a jury would be suited under whatever guidance is in this court's precedents to address that question.
All right, thank you.
I see that my time has expired. Thank you.
You will get your rebuttal.
Thank you.
Of course. All right. Thank you. Hello, Ms. Chenevert.
Hello. Good morning, and may it please the court. I'm Assistant Attorney General Caitlin Chenevert, and I represent the defendants' appellees. I would first like to note that this court should decline plaintiff's invitation to revisit its decision in Nelson, where at summary judgment, plaintiff acknowledged that RLUIPA does not include a damages remedy and that his RLUIPA claim was not being pursued.
May I interrupt? Because I'd like to ask you, I'd like to start you off this way. In terms of notice, would it be enough in your view if the statute said, quote, appropriate relief, including monetary damages, to make clear to a state and its officials that their decision to accept federal funds exposes them to damage awards in the event that they do not comply with the conditions that are imposed on their use of those funds? And I would really appreciate a yes or no response.
If the statute said appropriate damages may include monetary damages, that likely would be sufficient to put a state on notice that Congress intended to allow for monetary damages. However,
oh, okay. Oh, no. Finish your thought.
However, I would note that there still would remain the question of whether that would be sufficient notice that Congress intended to allow non-recipient of the federal funds to be held liable for a violation of the statute.
But I'm wondering then why the appropriate relief language by itself doesn't supply the requisite notice, given Tansen's explanation that the ordinary meaning of this phrase does include monetary damages.
The reason for that, Your Honor, is because Tansen did not analyze RLUIPA. Tansen was analyzing RFRA, and although RFRA is considered a sister statute to RLUIPA, it was passed pursuant to different powers, different congressional powers. And that context is incredibly important. The Supreme Court in Sossaman in interpreting RLUIPA specifically noted, when interpreting what the phrase appropriate relief means in RLUIPA, stated it is open-ended and ambiguous about what type of relief it includes. And then went on to say, far from clearly identifying money damages, the word appropriate is inherently context-dependent. And the context here is that RLUIPA was passed pursuant to Congress's spending power. And that distinction is important because the Supreme Court also has explained in Cummings that whether a remedy qualifies as appropriate relief must be informed by the way spending clause statutes operate. That is, by conditioning an offer of federal funding on a promise by the recipient not to discriminate at what amounts essentially to a contract between the government and the recipient of funds. So that is the context that is relevant for analyzing RLUIPA. That analysis about spending clause legislation is entirely lacking from Tansen, and understandably so, because Tansen analyzed RFRA, which was not passed pursuant to Congress's spending clause powers. I would also
Is that relevant to the statutory interpretation question, though, or is that relevant to the authorization under the spending clause itself? It seems like the statutory interpretation, the language is the language which is identical to the language in Tansen, and the argument you're making now about the spending clause goes more to Congress's power to pass this type of statute.
Your Honor, if I'm understanding your question correctly, I do not believe that a court is prohibited from looking at using statutory interpretation principles generally when analyzing spending clause legislation. In fact, the Supreme Court in Sossaman did that. It started its decision by analyzing RLUIPA, referencing RFRA, giving the full history of how RLUIPA came to be. So it started with that basic background of statutory construction and analysis. But then, because it was passed, RLUIPA was passed pursuant to Congress's spending powers, It turned to the specific question that must be asked when analyzing that type of legislation. And the context there, of course, was whether or not Congress clearly and unambiguously waived state sovereign immunity to monetary damages. And in that context, stated no, it was not ambiguous. But still, the United States Supreme Court in Sossaman, it did. It began with an understanding of RLUIPA, what its purpose was and how it came to be, but then turned to the relevant question. And indeed, again, at the start of its analysis, before getting to the question of whether it was unambiguous in the context of sovereign immunity, noted that appropriate relief is open-ended and ambiguous. This court, and in fact, the court, in making that determination, cited to this court's decision in Nelson. So Sossaman then conclusively answers the question for purposes of RLUIPA, whether or not appropriate relief is ambiguous. Indeed, it is. Turning now to the question.
So it's your argument that we have to look at the spending clause in construing the language in the statute, not just in assessing Congress's authority to do this.
That's correct, yes, that is correct, Your Honor. And again, turning to the context here.
Before you turn to the context here, so if that's correct, how does the necessary and proper clause apply?
Well, the necessary and...
Do we look at that for interpretation as well? Your opponent has raised that in their brief, and you didn't really address that particular question. Is that because you don't think it's relevant or something else?
Well, certainly, as far as the Sabry case, that case did focus nearly exclusively on the necessary and proper clause element and whether or not there was a sufficient connection between the federal funds and the conduct.
Right, for the
prohibited.
necessary part. Yeah.
Right, exactly. There wasn't a lot of discussion or analysis under the Congress's authority under the spending clause to pass the legislation in the first place. The court, of course, stated it what felt like it was a proper use, but there wasn't a full analysis of that issue. But before you could get to the question of whether or not the legislation complied with the necessary and proper clause, I do believe it would first be required to determine whether or not Congress had the authority at all to enact that type of legislation.
And do we look to the necessary and proper clause to make that determination?
No, I do not believe so. The Supreme Court has explained in Cummings, in Pennhurst, as well as in Barnes, that the question for determining whether or not this type of remedy is available centers on whether the statute unambiguously expresses that remedy is available. And then the notice requirement, in addition to requiring that a state may be on notice that a remedy may be available via unambiguous language, but also considering questions about whether that type of remedy would be traditionally available under contract law. That might also provide a basis for a state being on notice that it would be subject to this type of liability or this type of condition. Here, essentially what plaintiffs would be seeking to do would be imposing liability on a non-party to a contract and allowing another non-party to a contract to sue for breaches of that contract. That is not, as far as I'm aware, a traditional understanding of a remedy available under contract law.
How do you respond?
Oh, okay. No, go ahead.
Just one more question along those lines. How do you respond to the argument that was raised in the reply brief that if we agree with you and agree with your contract analysis and it shouldn't apply here, that there are other contexts and other statutory schemes that are going to be jeopardized, such as Title 10? And if it was raised in the reply brief, so I know you haven't had a chance to respond to it yet. And if you're not ready today, then we can ask for something supplemental if we need.
Yes, I would be happy to file a supplemental brief as to that question specifically. I guess I would just reiterate that typically spending clause legislation is understood as allowing remedies against or damages or liability against the funding recipient And that is typically the way in which spending clause legislation is understood, again, given the nature of the contract between the funding recipient and the federal government. But I'd be happy to submit a supplemental briefing on that specific point if the court would like.
Now, I'm going to go back to the phrase appropriate relief. If we were to decide that that phrase, appropriate relief, includes money damages, there really wouldn't be any remaining question that state officials and employees in their personal capacities could be held liable for such relief under the statute, would there be? Look, I realize it's the state that receives the federal funds and not its officials and employees, but doesn't the statute itself make clear that government means its individual employees and officials?
You are correct, Your Honor, that the definition of government in the statute includes government officials. So there is perhaps in that instance, with that definition of government, as well as a specific statement that appropriate relief includes monetary damages, that may be sufficient to unambiguously provide that type of remedy. But the additional question would need to be answered as to whether or not Congress exceeded the scope of its powers under the spending clause in enacting that type of legislation.
Now, of course, Illinois employees are indemnified for any damages that are awarded against them for any wrongs they may, commit in the course of their employment. How would that factor, if at all, into any analysis here, do you think?
Your Honor, I do not believe that would factor in at this point. The fact that Illinois may choose to indemnify its employees in these types of situations is separate and distinct from the question of whether or not Congress had the authority under this spending clause to enact that type of legislation and ask states to impose ask states to allow their citizens to be subject to that type of liability without being subject to the contract themselves. Several other circuits who have analyzed this issue have raised these concerns about the possibility that this would very likely exceed Congress's powers under the spending clause. Indeed, there's lots of constitutional considerations that might need to come into play. Specifically, the fact that, as the Supreme Court in South Dakota versus Dole discussed when it comes to spending clause legislation, there are limits on Congress's ability to enact certain laws on the states. And one of those is other constitutional provisions that may prohibit that type of legislation. And to the extent that that type of legislation may infringe on the state's 10th Amendment rights to pass laws and legislation concerning the liability of its own citizens. So certainly there are constitutional concerns that would still come into play, even if the statute was crafted so that it was unambiguous that that was Congress's intent. I would just like, going back to Sossaman for a moment, if I may, in order for this court to pivot from its understanding in Nelson that that appropriate relief in RLUIPA was ambiguous, that would put it in direct conflict with the Supreme Court's analysis of that phrase in Sossaman, which again specifically analyzed appropriate relief in the context of RLUIPA. And before getting to the question of the context there of whether it expressly waived state sovereign immunity, noted that it was unambiguous, or that it was open-ended and unambiguous. One further note, I see that my time is up.
But didn't Tansen distinguish Sossaman on the ground that sovereign immunity is not at issue when one is addressing the liability of state officials and employees in their individual capacities.
Your Honor, you are correct. At the end of Tanzan, the Supreme Court did make that distinction. But at the start of Tanzan, the Supreme Court cited to Sossaman and again reiterated that the phrase appropriate relief is open-ended and ambiguous. So it did not in any way undermine the Supreme Court's holding from Sossaman.
But because, look, as I recall, the court treated the meaning of appropriate relief as being context dependent, as we've said, and it found that in the context of individual capacity suits, appropriate relief was not at all ambiguous and plainly inclusive of monetary relief. So having a little bit of difficulty with, the view here.
Again, if I may briefly respond to that question.
Absolutely, you may respond.
So you are
not so briefly. We're here. We're here to hear you.
Your Honor, you're correct that Tanzan did reiterate that appropriate relief is context dependent. The context there was that a different statute, although similar to RLUIPA but not the same statute, RFRA was passed pursuant to Section 5 of the 14th Amendment, and RLUIPA was passed pursuant to Congress's spending clause powers, and the Supreme Court instructs that the context for understanding what remedies are available in spending clause legislation requires Congress to unambiguously provide that a remedy is available, and that is not present here in RLUIPA. For all those reasons, we ask that this court affirm. Thank you.
Thank you so very much. And Mr. Halpern.
Thank you, Your Honors. A few quick points. I want to start with why Congress possesses this authority, talk about the methodology under the spending clause, which goes to Your Honor's questions, and then close with a quick note about the text. So Congress possesses the power to impose liability against employees because of the conjunction of the spending clause and the necessary and proper clause. This court did not address that argument in Nelson, but Congress must be able to prevent non-recipients, especially employees, from interfering with the execution.
Why do we have to look at the necessary and proper? Why can't the analysis just focus on the spending clause and the contractual analysis of the spending clause?
You could, but the employee is not the recipient of the federal funds. So as in Sabri, I do think the necessary and proper clause bolsters our argument. I don't know that we would necessarily need it, but it makes the case easier. And we know that Congress has to have this authority under the necessary and proper clause because it needs to have a way to ensure that the agents of funding recipients are following its conditions.
Mr. Halpern, perhaps you could help me with the language in Tanzan. Where it cites Sossaman. It says, because the language is, quote, open-ended on its face, what relief is, quote, appropriate, close quote, is, quote, inherently context-dependent. What are we to make of that language?
I think the operative distinction between Tanzan and Sossaman was the capacity in which the defendant was sued and not the authority under which Congress enacted RFRA and RLUIPA. And Tanzan makes that clear. It says that damages were inappropriate in Sossaman by virtue of sovereign immunity. But this case is not about sovereign immunity, as Your Honors recognized at the start of this argument. This is an individual capacity case, and in that context, Tanzan makes clear that all of the traditional tools of statutory construction point in the same direction and in favor of damages. Damages are the presumptive remedy when a state official violates federal rights. So if you're forced to choose between appropriate relief meaning no relief or meaning the presumptive form of relief that has been available for 150 years, I'd respectfully proffer that the only plausible construction is that appropriate relief means damages.
Do you analogize this to a 1983 suit?
It's not me, Your Honor. Tanzan did that. Tanzan said that Congress was clearly pulling on the remedies available under Section 1983 when it enacted RFRA, and RLUIPA's language is identical.
So this inherently context-dependent, what do you think the court was referring to there?
So the words appropriate relief literally mean proper. To determine whether damages are proper, you have to look
I
at
understand.
the context. Sure.
Proper, but what is inherently context dependent? Why that gets me back to this factual aspect. Why is there a cite to that language?
I think that Tanzan was squaring its holding with Sosaman, and it was squaring its holding by observing that individual capacity suits are fundamentally different from suits against the sovereign. Those are different contexts, and while damages are inappropriate against the sovereign, they are appropriate against state officers in their individual capacity. And if I could just add one point.
Absolutely.
Yes, Your Honor.
Absolutely. You may. Absolutely. Go ahead.
Sure. So on the question of whether Congress possesses this authority, so there is Sabri, which we think ends the case, but there's also Oklahoma versus U.S. Civil Service Commission, where the Supreme Court upheld the Hatch Act's removal provision against an objection by the state that it would violate federalism principles for the federal government to demand that state officials be fired because, of course, they're not recipients of the funds. But the Supreme Court said that that was an appropriate exercise of Congress's prerogatives under the spending clause. And while Rust versus Sullivan is not a spending clause case, the operative principles in that case, that the employees could not complain about the limitations in Title X programs, applies equally here. Because in Rust, the court said they signed up for that scheme, they knew what they were getting themselves into, and their constitutional objections vanish when they knowingly consent to employment with a funding recipient. That exact logic applies here, and it shows that this form of relief is not remotely remarkable. State officials have been held accountable when they violate federal rights for the last 150 years, and we'd respectfully suggest that they should be held accountable here. We'd ask the court to vacate or reverse.
Mr. Halpern, you were appointed, were you not?
We were not appointed, Your Honor, but we are representing Mr. Walker pro bono.
All right. Well, that's even better than being appointed, isn't it? Anyway, we certainly want to thank you for, your vigorous advocacy, and we want to thank the Amici for their helpful work in this case. And as always, we thank the government, Ms. Chenevert, for her fine work. So, thank you, is what I'm trying to say. And the case will be taken under advisement. All right. We'll wait till everyone leaves. Okay, I think we're ready. So we will call the second appeal of the day. That is appeal number 22-2404, Todd Reardon Sr. versus Jesse Daniel. Good morning, Mr. Reardon, yes?
Good morning, Your Honor. Attorney Todd Reardon Jr. here on behalf of the plaintiff appellant. May it please the court.
Of course. Anytime you're ready, you may begin.
Thank you, Your Honor. Your Honor, this matter stems from an appeal of a motion to dismiss based on the district court alleging that there was no viable claim from the plaintiff appellant's complaint, going in no particular order. I would begin with the basis of the Coles County Board of Illinois and Stan Metzger, specifically with regards to Mr. Metzger initially withholding an election sign of Todd M. Reardon's by a candidate.
Mr. Reardon, I'm sorry, before you go too far, I just want to confirm, based on the briefing, it does not look like you are appealing the district court's ruling as to Mr. Metzger in his individual capacity. You are only appealing the Monell against the board. Is that correct?
Your Honor, I believe the two intertwine.
Well, they're separate, and they're separate elements, and they were separate claims. So I didn't see anything in your brief arguing against the district court's ruling on count 5 as to him individually. So.
Yes, Your Honor. Again, I believe with regards to the ratification of Mr. Metzger's investigation of himself, this is what's inherently intertwines the Monell claim to his actions, in that the Coles County Board did in fact ratify
And I understand you are appealing the ratification issue against the board.
Yes.
I just didn't see anything against Mr. Metzger individually in terms of your appeal.
I believe Mr. Metzger's actions before the board, Your Honor, do constitute its own separate action, and I believe that my brief did allege that against Mr. Metzger as well, but if necessary, Your Honor, I would perhaps point to the plain error issue of the matter. Again, I would still reiterate that the investigation by Mr. Metzger of himself before the Coles County Board was ultimately the Monell violation as well as the 1983 violation by Mr. Metzger himself.
I also have a question regarding Mr. Metzger because, of course, not every action of a public official, or I guess not every action that a public official takes is one taken under color of law for purposes of a Section 1983 claim. How do we know that Mr. Metzger was acting as a member of the county board as opposed to as a private citizen or an official of the local Republican Party when he removed the campaign sign?
Your Honor, it's the in tandem action of removing the sign, but then also presenting that issue before the county board as if it were part of its own agenda as a municipal corporation. In effect, Your Honor, Mr. Metzger, maybe by taking the sign alone, was not acting under code of law, but when he decided to present his actions before the county board as something to be approved of or something to be heard upon the agenda of the municipal board, that is when he then involved the board and himself under color of law, acting as a county board official to enact some type of almost quasi-ordinance, in effect claiming that what his actions were could not be construed as criminal. And so by presenting his actions to the board as something to be approved of, that is what ultimately the board ratified, his investigation of himself in taking that sign, which...
But there was no allegation that the board actually approved Metzger's actions, rather that it simply accepted his explanation that he removed the sign by mistake and determined that no further action on the board was warranted. And there wasn't. Maybe I missed it, but was there an allegation that the board harbored an improper motive in doing so?
No, Your Honor. I think by having at least the plausible deniability of claiming that it was an accident, Mr. Metzger, in effect, gave the board a pass to approve of his actions as simply that. But anyone who's potentially criminally liable would, of course, insist upon their innocence, as Mr. Metzger did. And so when the district court focused on Mr. Metzger's answer as, I believed I was acting under mistake of fact, just by hearing that, just by ratifying his desire to put this matter before the board as if it were part of its agenda, that ratification of his investigation is ultimately the Monell claim, a 1983 claim.
But ratification of the investigation is not enough under the law. The board has to ratify the decision as well as the basis for it, the alleged improper basis for it. But when Metzger went before the board, he said, I made a mistake, which is not an improper basis. And that's what the board forgived him for. Not because he went in and said, I took the sign because it's of a different party and I wanted to take it out.
I believe the improper basis, Your Honor, was presenting it before the board as an issue that it could handle or that it could somehow have any opinion on.
How could that be ratification? Because the board's not deciding anything with respect to a motive or a reason for doing something.
I believe the board did determine that his criminal investigation of himself was adequate for purposes of, again, a bit of a, it is all outside of the scope of the board's authority, But despite that, by just acting in fruition with Mr. Metzger, giving it any even appearance as if this could somehow negate an actual criminal investigation of his acts, that was, again, going further back from the district court, not so much what Mr. Metzger claimed to be his basis, but just by the board allowing him to present it as, this is the results of what I've determined for myself. I have determined that me taking the sign was not criminal, and I would ask that the board approve of that and confirm that that is at least basis sufficient for me to continue on the board. So for that reason, Your Honor, I would maintain and insist that the ratification did occur, not of the presented issue of I made a mistake, but rather I have entertained an investigation, and I am presenting that investigation to the board for its...
What investigation?
The investigation...
What, that Metzger found out that he had, that the resident had given permission?
Mr. Metzger had determined that he had not criminally or committed any criminal conduct, Your Honor. He did not have the permission of the resident. He had taken the sign. The resident had alleged that criminal conduct had occurred, and Metzger had presented this issue to the Coles County Board as a matter, again, to be heard on its agenda, which it did place on its agenda, and it did, in some format, approve of his investigation of himself.
Did he place it on the agenda?
He did, Your Honor.
If that's your theory of ratification, that it's based somehow on a criminal investigation theory, how is that a violation of the First Amendment? What you have pled is that this is a violation of the First Amendment because he took the sign for inappropriate reasons, and the board ratified him taking the sign and the inappropriate reasons.
In that he was interfering with Todd Emeren's right to run for election, Your Honor.
But how is a ratification of a criminal investigation a violation of the First Amendment?
By essentially construing that him taking these signs, by him interfering with Mr. Emeren's right to run for election, could be absolved by the board's determination that, at least whatever they could determine, no ethical violation had occurred, as well as muddying the waters of any potential criminal investigation by overlaying some kind of, again, color of law that Mr. Metzger had in fact presented something before the board that was...
Could we go on to another issue, please?
Yes, Your Honor.
In what sense did the photo with Chief Taylor and the endorsement on the police department Facebook page deprive Mr. Reardon of his own First Amendment rights? I appreciate the fact that city resources may have been or were improperly used, but nothing prevented Mr. Reardon from obtaining and promoting his own endorsements, did it?
No, Your Honor. However, I believe what's necessary for the context of this case, acknowledging that the district court relied primarily on Shackman, I believe there's still ample room to allege that when you are interfering with the right to run for election, that especially in a zero-sum situation where you have one candidate versus another, when one candidate has been given the patronage or have been given the approval of a municipal agency, the chief of police of a police department, which the district court did concede very likely was official misconduct, when that is being used to the benefit of one candidate over another in a two-way race, it cannot really be understood in any other way but to be essentially restricting the First Amendment rights of the second candidate from being able to run free of government interference.
Well, wait. In terms of equal protection, did Mr. Reardon ask the Mattoon Police Department to remove the endorsement from its Facebook page, or did he ask the city to give equal treatment to his own endorsements?
No, Your Honor, Mr. Reardon did not make that request, and in light of, again, the fact that Mr. Jason Taylor likely committed official misconduct, he would not have requested that.
But violation of a state ethics law is not an equal protection violation.
In itself, no, Your Honor. I believe, however, again, in the context of this specific case where you have only two individuals running, to say that one side now has the instruments of local government somehow benefiting them solely, it can't be construed any other way than as a restriction on the other side's ability to run. And I would concede if perhaps it were a three-way race or something of that nature, it could be more nebulous to say whether this action directly benefits one candidate to the detriment of another, so much so that it creates government interference. But here, where you have only two candidates and a police department, or at least the chief of police acting as chief of police or under color of law, ascribing to one candidate that we are supporting this candidate, this municipal agency is supporting this candidate and is providing him funds, resources, office locations that the other candidate does not have access to because the other candidate is not requesting someone to commit official misconduct.
Mr. Reardon, I want to, in the time remaining, turn to a different issue. You've brought a claim based on the documents that were obtained and subpoenaed from Facebook. And part of your claim is based upon the release of those documents. Looking at the record in the case, it's unclear to me, has Judge O'Shaughnessy ruled on the release of the subpoenaed documents that were received?
No,
from
Your Honor,
Facebook?
the documents have yet to be released.
Then how can you base a claim on the release of those documents if the state court hasn't ruled on that issue yet?
Your Honor, if I understand your question, I believe the issue with both the judge and I would say separately the original subpoena that was issued by the state's attorney's office, with respect to the Younger doctrine, Your Honor, I don't believe it could be applicable at all to the original issuance of the subpoena, just in light of the fact that first, one could allege that there was no state court proceeding ongoing. It was simply...
But before we even get there, I'm trying to figure out what your claim is and if it's ripe. If you're bringing a claim based on the judge's ruling on the release of the documents, the judge hasn't ruled on that.
In essence, Your Honor, we are asking for injunctive relief against Judge O'Shaughnessy for the returning of those materials to plaintiff appellant.
He hasn't ruled, though. There's something pending before him. You requested the release, but he hasn't said one way or the other.
Yes, Your Honor. I think, again, going back to why this is still appropriate for federal intervention is in light of the fact that, one, how the subpoena came to be issued was during the ongoing campaign between Jesse Danley and Todd M. Reardon, in which the Younger abstention does point out a bad faith exception as outlined in the Collins v. County of Kendall that the district court relied on. In that matter, Your Honor, it was admittedly a one-to-one relation of political activity being prosecuted by, directly for that basis. Here we have a slightly roundabout method in which, rather than going directly after the individual for what's obviously their right to seek election, a roundabout method of simply prosecuting the individual on some other basis, despite that same individual being your political opponent, speaks directly to the issue of Collins v. County of Kendall as far as the chilling speech aspect of the bad faith exception. Here we have, and I apologize, Your Honors, I asked to reserve.
You'll get it, but go ahead.
Thank you, Your Honor. With regards to the bad faith exception, we have, I think, a very similar parallel, despite the district court's ruling, to Collins v. County of Kendall, because it is, in fact, a chilling effect of prosecuting your political opponents as you are in an ongoing campaign against them.
Can you hold on for a minute? Because now I'm a little, Did Judge O'Shaughnessy ever release the subpoena materials to the officials conducting the investigation? To no one, period?
They were not released to anyone, Your Honor.
Well, now, could there be a potential mootness issue?
Your Honor, I think with regards to the original subpoena that was issued, and I would note, as alleged, issued without any underlying case, without any original search warrant ever issued before it. It was simply sought out as, it's not as compulsory process, but as a quasi search warrant by the state's attorney's office, or at least acting under a color of law as the state's attorney's office by Jesse Danley. Because of that, Your Honor, I think the invasion of privacy occurred the instant that that subpoena is sent out, and my client's private materials are then taken, or sent by Facebook honoring the subpoena, and then withheld by my client in now the Vermilion County Circuit Clerk's Office. But based
Okay, now I think we need you to, wrap up.
Excuse me, Your Honor.
I'm going to give you, some time because we've peppered you, but still.
Just in essence, Your Honor, addressing the last factor, again, there is a Fourth Amendment violation that does fall under the bad faith exception here, because we don't have a valid case. We have a subpoena that doesn't exist in a valid case, and then we also have that subpoena being issued under color of law by the political opponent of the same of that individual, Mr. Reardon. So I believe it speaks directly to the bad faith exception considered in Collins v. County of Kendall, Illinois, with regards to chilling the speech of Mr. Reardon in his ability to seek election without being prosecuted by his opponent. Thank you, Your Honor.
Thank you very much. Okay. Good morning, Mr. Drinkwine, yes?
Good morning, Your Honor, yes.
Anytime.
May it please the court and good morning, counsel. Chris Drinkwine on behalf of Coles County State's Attorney Jesse Danley, and Board Member Stan Metzger. I'll also be presenting argument this morning on behalf of the City of Mattoon and its former Police Chief Jason Taylor, as the city defendants and the county defendants have filed a joint brief in this case. The district court dismissed...
Do you know the status of the Facebook records, or is that question better for your opponent?
Well,
or your co-counsel, I should say.
My understanding is the same, but I would also remind the court that the allegations in the complaint are what's important in this case. We're on 12b-6, and there's no allegations in the complaint that that has been ruled on either. And a couple of times counsel went beyond the allegations of the complaint, but I'll come back to that.
But my question is, if they haven't been turned over, and part of the violation is based on the state court ruling on it and turning it over, how is that ripe?
Well, he's asking for injunctive relief. I mean, he's asking...
But it still has to be right for injunctive relief.
Correct. And from the perspective of the state's attorney, the Younger abstention ruling by the district court was correct with respect to any injunctive relief against him. And the Assistant Attorney General will address momentarily the injunctive relief against Judge O'Shaughnessy. The district court dismissed 3 First Amendment claims and 3 equal protection claims regarding the photo incident. On appeal, plaintiff challenges only the equal protection claims being dismissed, which is not surprising considering that the First Amendment claims seek to hold liable Chief Taylor and State's Attorney Danley for conduct that itself is protected by the First Amendment. The district court correctly determined that plaintiff failed to state equal protection claims because the photo incident allegations do not fit into the interests of political candidates that are protected by the Equal Protection Clause. Specifically, there's no allegation that Danley compelled or coerced Chief Taylor to pose for the photograph. If he had, that would have violated equal protection under the Shakeman v. Democratic Organization of Cook County case, which explicitly distinguishes between compelled and voluntary political support by public employees. There's also no...
Forgive me, suppose Mr. Reardon had obtained endorsements from other Mattoon officials, and once he saw Chief Taylor's endorsement, he asked the city to post his own endorsements on its Facebook page, and the city refused. Might he then have had a legitimate First Amendment or equal protection claim in that instance?
Your Honor, I hesitate to speculate on something like that where there's no such allegation in the Second Amended complaint, which was Mr. Reardon's third attempt to state a claim under the Equal Protection Clause or the First Amendment. But if I were to hazard a guess, if there could be an equal protection problem, I suppose if they treated them differently with respect to access to their Facebook page. And with regard to the equal protection claim, the district court not only determined that plaintiff failed to state a claim, but that even if he had, for purposes of argument, Taylor and Danley were entitled to qualified immunity because plaintiff's equal protection right with respect to the photograph was not clearly established at the time of the alleged violation. Significantly, plaintiff advances no qualified immunity argument before this court on appeal, and therefore he has necessarily not identified any case authority clearly establishing an equal protection prohibition against one public official endorsing another by posing for a photograph together. And in fact, the law is the opposite. For example, in Gonzalez v. Madigan, this court called into serious question its previous decision in Smith v. Cherry, which held that a political deceit in the form of stalking horse candidacy could potentially violate equal protection. Now, the court didn't overrule Smith v. Cherry, but it called it a bolt from the blue and held that it shouldn't be extended further. So this court's decision in Gonzalez v. Madigan makes it sufficiently clear that a candidate's mischief or shady strategy or tactics during an election will rarely, if ever, violate the Equal Protection Clause of the 14th Amendment. This court wrote, "The Constitution does not authorize the judiciary to upset an election outcome or to penalize a petition for employing a shady strategy that voters tolerate." The court in Gonzalez also quoted an earlier case stating that any effort by the judiciary to stop one politician from taking steps that injure another politician would do more to violate the First Amendment than to vindicate the Equal Protection Clause. Defendants respectfully submit that there is nothing shady or mischievous about one public official endorsing another and demonstrating that endorsement by posing for a photograph with the candidate. It certainly doesn't rise to the level of shadiness or mischievousness in a stalking horse candidacy or the placement of stooge candidates on a ballot to split the Hispanic vote, as was alleged in the Gonzalez v. Madigan case. So not only is there no authority demonstrating that the photo incident violated the Equal Protection Clause, Gonzalez v. Madigan establishes that plaintiff had no such right. Having not made a qualified immunity argument with respect to the photo incident, it appears that plaintiff does argue that Chief Taylor's decision to pose for the photo with State's Attorney Danley was a decision by a final decision maker for the city of Mattoon, such that the city can be liable under a Monell theory. But this argument fails because there's no allegation in the Second Amendment complaint that Chief Taylor was a final decision maker for the city of Mattoon regarding the endorsement of political candidates. And even if he was, there's no underlying constitutional violation that occurred as a result of the photo incident. So the district court's order dismissing the equal protection claims against Danley, Taylor, and the city of Mattoon was entirely correct and should be affirmed. On the sign stealing incident, Your Honor asked the question about the individual claim and the Monell claim. And I think we heard a concession there at the end of that part of the argument, but the Monell claim is the only one being argued by plaintiff, and specifically on page 13 of his appellant's brief, the plaintiffs wrote that when defendant Stan Metzger first converted and concealed the aforementioned sign, he may not have been acting under color of law, much like the scenario in Wilson. And Wilson v. Price is on all fours. There was no state action by Metzger. And because there was no underlying First Amendment violation, there can be no Monell liability against the city of Mattoon. Plaintiff does make the argument that Metzger's earlier actions became retroactively adopted by the Coles County Board, but the district court correctly determined that plaintiff failed to state a claim under a ratification theory because there was no allegation in the Second Amended complaint that the county board actually approved Metzger's conduct, and no allegation that the board actually approved any motivation on Metzger's part to violate plaintiff's constitutional rights. Instead, plaintiff has specifically pleaded that the board accepted Metzger's explanation and determined that no further action was required because he made a mistake, not because he violated his constitutional rights. Plaintiff has not explained on appeal why that analysis was wrong. So for those reasons, the district court correctly dismissed the First Amendment claims alleged against Stan Metzger in Coles County based on the sign stealing incident. The injunctive relief sought in count 2 against State's Attorney Danley from receiving the subpoenaed information was dismissed by the district court on younger abstention grounds. This court reviews that decision de novo. It's important to note, though, with respect to the posture of the case, procedural posture of the case being the 12b-6, that there's no allegation in the second amended complaint that plaintiff had announced his candidacy for state's attorney or filed a petition for nomination as of October 10th, 2019, the date that the subpoena was issued. And that allegation would be necessary in order for it to be plausible that that subpoena was issued in retaliation for plaintiff running against State's Attorney Danley. I see my time has expired. For all these reasons, the City of Mattoon defendants and the County of Coles defendants respectfully request that this court affirm the judgment of the district court.
Thank you very much. Thank you, Mr. Drinkwine and Ms. Jennifer.
Good morning, Your
Hello.
Honor. Hello again, Your Honor. Good morning, and may it please the court. I'm Assistant Attorney General Caitlin Chenever, and I represent the defendant appellee, Judge Thomas Judge O'Shaughnessy. I would first like to note that the district court below found that the judge was entitled to absolute judicial immunity because Mr. Reardon had failed to allege that declaratory relief was unavailable or that a declaratory decree had been violated. On appeal, Mr. Reardon largely fails to address that argument or that decision from the district court at all. Instead, in a very brief assertion in the summary of the argument, just simply asserting that no declaratory relief was available. But in his opening brief and in his opening arguments to this court, Mr. Reardon has not challenged or given any reason for this court to disturb the district court's determination here, dismissing the claim as to this judge. To answer Your Honor's question about the status of the Facebook documents, it is my understanding that those have not been released yet. That is my understanding as well.
It seemed odd to me because the motion to quash was ruled on and appealed. So if there was still an open question about turning them over, how it was final for appeal purposes.
Your Honor, the order denying the motion to quash was appealed, and the appellate court decision, it does not specify whether it was exercising jurisdiction over a final and appealable order or an interlocutory order. There is case law in Illinois that says that it can be a final and appealable order when an individual is appealing an order denying a motion to quash. So that is certainly a possibility, though it was not specified or stated in the Illinois appellate court decision.
So should we address that in terms of Rooker-Feldman if that's final, rather than Younger?
Well, certainly to the extent that there are any other matters pending, which it appears there may be, to the extent that these documents have not been released and there's been any request for them to be released, then Younger would be the appropriate abstention doctrine here to allow the state court to complete litigating the matter and reach its rulings, and also to allow Mr. Reardon, to the extent that he feels he may need to, file any appeals in the Illinois Appellate Court in the first instance. But aside from that, if the case is over, which I would note in the response to the judge's motion to dismiss, that's District Court Doc 4 at page 2, or I believe 40 at page 2, in the response, Mr. Reardon argued that the judge found that the matter was moot, given that the state's attorney had not requested the release. And so to the extent that the matter is at this point concluded, then it would be final and Rooker-Feldman would be implicated. Because to the extent that Mr. Reardon is seeking the release of those records, he would need to appeal that decision through the Illinois Appellate Court instead of turning in the first instance to the federal district court. I would also note that specifically as to the district court's determination that absolute judicial immunity applied here, as the district court noted, Mr. Reardon did not allege or explain that there was no declaratory relief available to him here, and Section 1983, after its amendment in 1996, does require that before injunctive relief is available, a declaratory relief must be unavailable, or there must be an allegation that a declaratory decree was violated, which is not present here in any of the allegations. In this
Don't we have waiver here on this whole argument? The argument in this case, in this issue, is all perfunctory.
Oh, waiver as far as Mr. Reardon's challenge to the...
Yes.
Yes, that is correct. There's a single, in the summary of argument, there's a single assertion that declaratory relief was unavailable. And then in the substance of the argument regarding the dismissal of the judge, the plaintiff raises what appears to be a new argument on appeal, which, as I understand
Well, it's raised for the first time on appeal, isn't it?
Correct, yes.
Well, then you can't do that.
That is correct, Your Honor. You cannot do that. And in any event, none of those arguments go to the reasoning underlying the district court's decision. For all those reasons, we ask that this court affirm.
Thank you.
Thank you.
Thank you very much. Mr. Reardon? Give Mr. Reardon 3 minutes, because it really wouldn't be fair otherwise. Go ahead.
Thank you, Your Honor. Just briefly addressing counsel's points in order. With regards to the equal protection claim, Your Honor, I think counsel stated somewhat clearly that if the candidates had been treated differently with access to government resources, access to government offices, and ultimately, I guess you could say, government approval, at least acting under color of law as such. And that's exactly what happened here, was that in fact, one candidate did receive the benefits of a police department's resources, a police department's access to their privately controlled Facebook page, to their office, to their ability to proliferate that. That is discriminatory, Your Honor. That is, in essence, Mr. Reardon having to run for election against, ultimately, the municipal government in some form, or at least as much as that government is providing the other candidate in a two-sided race with governmental resources that Mr. Reardon does not have access to, and like previously stated, would not have requested, just in light of how egregious that would be. Also, pointing to counsel's reference to the qualified immunity of Jason Taylor, relying on the district court's ruling that there was no clearly established basis that Mr. Taylor would have reasonably known that he was violating Mr. Reardon's rights. Well, Mr. Jason Taylor did know, or at least should have known, that he was committing official misconduct. He should have known that he was potentially committing criminal conduct, and that he was committing this criminal conduct in an ongoing election to the benefit of one candidate over another. So although there may not be a close parallel, just perhaps because there's not many individuals that would have, for lack of a better term, risked their own necks for someone else to such degree, it does nonetheless remain a viable cause of action that they are not immune and that they should have seen a reasonable basis of violating Mr. Reardon's rights by committing crimes in an ongoing election to the benefit of one candidate over another. With regards to Stan Metzger, and I realize I am running short on time, I would just point out that it is, in fact, the opposite of the precedent of Wilson v. Price, in as much as Wilson v. Price, that individual never went to the board, never went to the legislative capacity of his local county board, or excuse me, I think it was a city board, for that action. And in Wilson v. Price, of course, it was, I believe, battery. Here it's theft. However, it's chronologically opposite, just in that Mr. Metzger went to the board for approval of his actions. The alderman did not do that. And that would be the end of my time. Thank you, Your Honors.
And we thank you, and of course, we thank all of our lawyers, Mr. Drinkwater and Ms. Chenoweth. And the case will be taken under advisement, and the court is going to take a 10-minute recess. All right. Are we ready?
Yeah, counsel's at the table.
Thank you.
Counsel.
Okay, yeah, I was muted. The next case is appeal number 222666, Monta Anderson versus the United States, and Mr. Flutterman. Hello.
Hello. May it please the court, Eric Flutterman for petitioner appellant Monte Anderson. The Sixth Amendment guaranteed Mr. Anderson a lawyer who would learn the facts of his case and who would advocate for him during the negotiation of his plea. What he got instead was a lawyer who recommended that he take a plea deal for a 20-year prison sentence without investigating whether the government could prove its case for an enhanced sentence. Now that this case has been subjected to the kind of adversarial testing that it should have received during Mr. Anderson's original criminal proceedings, it is clear that the government's case against Mr. Anderson had flaw after flaw that his lawyer did not discover and indeed did not investigate.
Now, our decision in the last appeal presumes that the death results enhancement was the only way that Mr. Anderson might be subject to a mandatory life term. And so I take it that your position here is that we should not consider whether there might have been other grounds on which Mr. Anderson could have been subject to a mandatory life term because the government did not raise them in the last appeal, in the prior appeal. Is that right?
That would certainly be my initial argument, yes, Your Honor, that this is the law of the case. The government did not raise this argument on the initial motion to dismiss proceedings, nor on this case's last trip to this court. The first time we hear about these predicate convictions as being a reason why she did not investigate was at the evidentiary hearing. However, if this court were to consider those grounds as some kind of, as I'm sure the government will argue, as some kind of strategic reason why she did not investigate or contact a toxicologist, well, in that case, then we look to the evidence and the arguments that we presented to the district court about these predicate offenses. And the evidence that was presented in the district court shows that Ms. Schneider-Hines did not investigate any of the three noticed predicate offenses that the government intended to base an enhanced sentence on in this case. Notably, Strickland sets the standard here. Strickland states that strategic choices made after less than complete investigation are reasonable precisely and only to the extent that reasonable professional judgments support the limitation on investigation. And so the question here is, did Ms. Schneider-Hines make a reasonable professional judgment when she did not pick up the phone to call a toxicologist to try to understand the evidence that she admittedly did not understand and did not have the qualifications to understand? Did she make a reasonable professional judgment in not doing that because of these alleged multiple pathways to mandatory life that Mr. Anderson faced? Those pathways that she discussed and that were discussed at the evidentiary hearing were based on three predicate offenses, all of which had meritorious arguments against them that Ms. Schneider-Hines failed to identify. The first one was, I'm sorry, Your Honor, go ahead. Nope, I apologize. Your Honor, the first one, the 2009 attempted possession of heroin conviction, I think bears a little bit of discussion here. That one was so obviously not a felony drug offense that when Judge Mim ordered briefing on this issue below, the government had to concede that alleged felony drug offense that it had noticed during Mr. Anderson's original criminal proceedings in fact is punishable as a misdemeanor. It in fact was not a felony drug offense at all. The government conceded that below. And the fact that Ms. Schneider-Hines did not even mention that obvious flaw with that conviction is plain evidence that she did not investigate these prior convictions or whether they could support any kind of independent path to a mandatory life sentence.
Mr. Flutterman, are you arguing that there had to be a mandatory life sentence kicking in order for there to be ineffective assistance of counsel here? So in other words, if there were sufficient evidence that there was a 20-year mandatory minimum as opposed to life, do you agree that she could have been effective? Is your argument hinging on the life as opposed to the 20-year?
Well, Your Honor, the argument is hinging on the choice that Mr. Anderson was faced with.
Correct. I understand that, but underlying that, is it based on the 20-year as opposed to the mandatory minimum only?
Here, Your Honor, we are arguing that all of the bases for the statutory enhancement, the mandatory minimum of 20 years, could have been demolished.
That's what I thought you were arguing, but I thought I heard something different a minute ago.
Apologies, Your Honor. Yes, to clarify, Ms. Schneider-Hines could have and should have identified meritorious arguments to attack every single pathway to a statutory enhancement here. And is, as Ms. Schneider-Hines stated herself at the change of plea hearing, this statutory enhancement is what is driving Mr. Anderson's mandatory minimum. Her opinion at the sentencing hearing the change of plea hearing was that if the statute did not apply here, if we're only looking at guidelines, Mr. Anderson's likely guidelines range would be at or below 20 years. And that's what this court discussed and held in this case's last trip to this court. The likely guidelines range Mr. Anderson would be looking at would be something like 168 to 210 months. And Judge St. Eve, kind of expanding on your question, as I'm sure the government will argue, well, yes, there may have been arguments related to, whether you can attack different pathways to the statutory enhancement, but at the end of the day, one of those might have lost. He might have still been facing 20 years. Okay, fine. That is what this court held in the last opinion in this case, was that even if he's facing a mandatory minimum of 20 years, if he goes to trial, it is still perfectly rational for Mr. Anderson to reject a plea deal to a certain 20 years. Because even if that plea deal might shave off a little bit of prison time, Mr. Anderson still would have been perfectly reasonable and made the rational choice to reject that initial plea offer and to proceed towards trial.
Mr. Flutterman, if Mr. Anderson were to prevail and proceed to trial, am I correct in thinking that he does have at least one prior felony drug conviction, the 2020 Cook County cannabis conviction? And am I correct so far, or no?
Your Honor, it was, I believe it was a 2000 cannabis conviction, apology. That one, Your Honor, that one would not count as a felony drug offense for purposes of inclusion or for purposes of supporting a statutory enhancement here. That is because under the procedures set forth in Section 851, the government has to file an 851 notice that states all of the convictions that it is planning to rely on in order to enhance a sentence before trial or before a plea of guilty. Here, the evidence supports that the government didn't know about that 2000 cannabis conviction.
But nothing would stop the government from filing that if this went down for a retrial, would it?
Mm-hmm.
If it went down for a retrial, that's true, Your Honor. Nothing would stop the government from filing that.
And I think there were two that were identified in the PSR that had not been originally included in the 851 notice.
Correct. One of those was a cocaine conviction. It was subject to the exact same Ruth-type argument that we make with the 2006 cocaine conviction. So this cannabis one is really kind of the only one hanging out there for purposes.
But if the jury, let's say if the jury convicted him on the conspiracy charge and found him responsible for the serious bodily injuries to the other two individuals, he could face a mandatory life term, right? Or not?
That's correct, Your Honor. If the government were able to prove that the brief loss of consciousness by one of these victims was a serious bodily injury, and if the government were able to overcome arguments that, at least one of the predicate offenses counted, then yes, Mr. Anderson would be facing mandatory life in that circumstance. That is.
And does he appreciate the possibility? Do you know?
Your Honor, if we're talking about practical purposes here, if the court were to grant him relief, and if he were to go down and be reinitiated into these criminal proceedings, Congress has amended 841 under the First Step Act. So, in fact, the felony drug offense language that we're talking about has now been changed to serious drug felony. In order for something to be a serious drug felony, he has to have been actually imprisoned for at least a year in order for it to count. As we argued to the district court below that none of his prior convictions would count. So I realize that's a bit aside from the habeas proceedings here, but to answer your question, for practical purposes, the government has a much steeper hill to climb now with those amendments.
So a 20-year mandatory minimum sentence would apply if death or serious bodily injury results from the use of the heroin. I think you agree with that.
Absent any predicate offense is correct.
So putting aside the other convictions and the failure to investigate the death, we know that there were two other individuals here who overdosed from heroin and had to get hospital treatment. And that was known at the time. In light of that, how can we say that it would be objectively unreasonable for a lawyer to counsel against a 20-year plea deal?
Because by her own testimony, she thought that argument was unsupported.
But that's her
by
subjective
case law.
belief. I don't think that's something we look at. It's an objective test for purposes of habeas relief. And the question is, what would have been objectively reasonable to counsel, not to subjectively here? And that's what I'm struggling with.
Correct, Your Honor. And as Wiggins held and as this court held in the last opinion in this case, in order to make that objective assessment, you have to look at what evidence was available to the lawyer and what would it have been reasonable for the lawyer to press on in that circumstance. If the only, had she identified these arguments to the predicate offenses, and so now her multiple pathways to mandatory life is already off the table. Now she's looking at
This
20
is 20
years.
years. I agree.
And at that point, for her to not pick up the phone and consult with a toxicologist and say, hey, does the government's case related to, but-for causation of death here,
But that's a separate question. I don't disagree with you on the death issue. I'm focused on the serious bodily harm, which is separate. It's defined as a substantial risk of death under 21 U.S.C. 802.25. So if you have the risk of serious bodily injury, which is defined as a substantial risk of death, and you have two individuals who have overdosed on heroin and required hospital treatment, I come back to my question, how could it be objectively unreasonable to take this plea deal or to recommend this plea deal? Because that didn't require further investigation. We know the facts from the record. There were two individuals they overdosed on heroin, and they had to be revived, and they had to get hospital treatment.
With respect to those two individuals, one, William Holmes, there were clear causation issues that, in fact, that Ms. Schneider-Hines identifies in the record. That chain supposedly goes from Mr. Anderson to Mr. Mancini, who...
Do you need that but-for causation for purposes of the serious bodily injury?
You do.
Enhancement, not the death. I know we need it for death.
You do. It's
Okay.
It's in the same clause in the statute. You need that exact same exacting but-for proof. So with respect to Mr. Holmes, there are serious, even just chain of custody issues related to where he actually got the heroin from. With respect to Ms. Heilman, I think there's quite a bit of discussion about credibility issues. She was a purported co-conspirator in the case in state
But
proceedings.
credibility, she overdosed from heroin. What would that credibility go to? I think that fact is undisputed.
The fact that she required medical treatment after ingesting heroin is undisputed. With respect to, how she got the heroin, with respect to whether there was some kind of mixed intoxication here, similar to Mr. Reeder, these are open questions that, had we gotten to this point in the investigation, and where this, as she states, unsupported argument was the only remaining thing that the government could get to 20 years with, she absolutely would have pressed those challenges. I see my time has expired.
You will get your rebuttal.
Thank you, Your Honor.
Hello, Mr. Simpson.
Hi. May it please the court, Your Honors. I'm Scott Simpson on behalf of the United States. It would be tempting here, I think, to skip right to the merits. The court has a lot of issues that it's facing here, but we need to address a couple of additional issues before we get to the merits, I think.
I'd like to start you with this issue, because when I look at our decision in the last appeal, it seems very clear to me that we were operating on the assumption that the death results enhancement, coupled with one prior felony drug conviction, was the only potential trigger for a mandatory life term. And when I look at the government's brief in that appeal, I could not find any mention of either of the two alternative grounds for a mandatory life term that you raised before Judge Mim and in your brief here. Why didn't the government waive those alternatives by not raising them in the prior appeal? Wasn't that precisely the time to raise them?
Your Honor, two or 3 points on that. The issue here is whether the trial attorney provided ineffective assistance, and it's clear from the trial attorney's testimony at the remand hearing that she was aware of the actual state of Section 841 at the time, at the relevant time here. And I believe our brief in this appeal does state correctly the state of Section 841 at the time of Mr. Anderson's sentencing. True, and I apologize for this, our prior brief in this appeal did summarize Section 841 incorrectly. But that was, again, Anderson's attorney recognized it correctly, understood it correctly during the sentencing proceedings below, earlier during his trial time, and that is reflected in the remand hearing. And I believe that, again, our brief in this appeal does state that correctly. So some preliminary issues, Your Honors, and I think it's important. I think these issues are important because we need to defend the principle that an appellant cannot appeal issues that are not in the certificate of appealability, number one, and number two, that a defendant, a movant under Section 2255 cannot raise issues that are not in the Section 2255 motion. First of all, a few words on the scope of the certificate of appealability. Much of what Mr. Anderson argues on that issue in his reply brief, in a sense, misses the point here, because the district court here not only limited the certificate of appealability to the prejudice issue, the prejudice prong under Strickland, but also did not even decide that issue. So if this court were to address now the question of adequate performance, the first prong of Strickland, the court would not be deciding an appeal, but would be deciding that issue in the first instance based on the remand hearing testimony. And number two, although the district court did address the question of effective assistance in relation to the sentencing predicates, as has already been discussed, the court's certificate of appealability pointedly also omitted that question. So we have Mr. Anderson on appeal here has both of those problems in relation to what he is trying to raise on appeal, both the first prong of Strickland and the sentencing predicates. Neither of them should be involved in this appeal.
But look, assuming that we reach the potential alternative grounds for a mandatory life term, then why isn't it appropriate for Mr. Anderson to be able to argue that Ms. Schneider-Heinz was ineffective for failing to investigate his criminal history and to identify the various flaws with his predicate convictions? I mean, doesn't the reasonableness of her advice to accept the plea deal hinge not only on the viability of the death results enhancement, but also whether he actually had one or more prior felony drug convictions? And either of the two other alternatives for a mandatory life term you've identified requires at least one predicate conviction, if not two. So it seems very hard for me to leave his criminal history and what his attorney knew or did not know about it out of the analysis. And I think Judge Mims seems to have recognized that very point in his decision below. So
I can understand. I can understand that, Your Honor. But we also have a waiver issue on the part of Mr. Anderson.
Well, you have a real waiver issue too. So, I mean, but go ahead.
Actually, I'll go ahead and address that one first too, Your Honor. I believe it was Your Honor, Judge Rovner, who first raised that earlier today. So the argument that Mr. Anderson makes at this point, that his assertion that the government waived an argument that Mr. Anderson faced multiple avenues to a 20-year sentence, or of course also a life sentence in prison. Mr. Anderson agreed in his Type C plea agreement to a sentence of 20 years, and he says now that his attorney should have investigated further the cause of James Reeder's death. So in the course of having to address that, under the prejudice prong of Strickland, the district court has to look at whether the alleged failure on the part of the defense attorney prejudiced the defendant. And so in the course of doing that, Judge Mim, in his remand order, had to make the decision, was there prejudice? And the court said, no, there wasn't prejudice, because there were several avenues to a sentence of life in prison or 20 years. So logically, the court said below that Mr. Anderson would not have changed his plea and insisted on going to trial, even if his attorney had investigated further the cause of Mr. Reeder's death. So that's an essential part of the district court's analysis here under Strickland. That's not a claim that the government could have waived. It's just the outcome of that analysis, that essential analysis under Strickland. Even if we were to disregard all of those issues, Mr. Anderson now argues that he didn't need to assert the constitutional ineffective assistance in relation to his sentencing predicates. I think the argument that they make in the reply brief is that he didn't know he needed to do that before the remand proceedings. But Mr. Anderson obviously knew that he faced life in prison. He obviously knew that he he could not have gotten to that point of facing life in prison without at least one prior felony drug conviction. Also, in his plea agreement, Mr. Anderson acknowledged the fact that he faced a sentence of 20 years if he had one prior felony drug conviction, and he acknowledged in his plea agreement that he faced life in prison if he had 2 such convictions. And he also expressly waived in the plea agreement the right for the government to file an 851 notice. Section 2255 movements do, of course, sometimes assert that their attorney provided ineffective assistance in relation to looking into sentencing predicates. Mr. Anderson could have done that, and we submit that he should have done that if he wanted to challenge his counsel's assistance in that respect. We've referred a number of times here to this court's prior decision in this case. One of the issues that this court resolved in that decision was the court rejected the government's effort to raise a timeliness issue that was not raised below. This court, we submit, should take the same approach now in relation to Mr. Anderson's challenge to his sentencing predicates and reject the petitioner's effort now to raise a challenge regarding his sentencing predicates that he did not raise in his Section 2255 motion. So if I could talk a little bit about the sentencing predicates themselves, assuming the court gets past all of those procedural barriers. The question, of course, here is not just whether the sentencing predicates were valid or whether counsel provided constitutionally deficient performance in not challenging them. The question here is we assert, first of all, waiver, but even if it's not waiver, it's at least forfeiture. So Mr. Anderson has to overcome the forfeiture standard of review. He has to present extraordinary circumstances about whether counting those predicates under Section 841 constituted plain error. No matter what we think about at this point, or at the time of Ruth, no matter what we thought about those sentencing predicates, we have to look at it now through that lens of plain error. I think the number 4 has been talked about in relation to the number of Mr. Anderson's sentencing prior drug felony offenses. I think the actual number is 4. That is leaving aside the 2009 conviction, which we admit was a misdemeanor, so that doesn't count. But even aside from that, we have 4. The 2006 cocaine conviction in Illinois, the 2000 possession of cannabis conviction in Illinois, and the 2000 manufacture or delivery of cocaine conviction in Illinois, and number 4, the 2013 conviction for possession of heroin.
Well, you think there are 4, but let's just pretend that we think it's important to nail down how many, really valid predicate felony drug convictions Mr. Anderson had, and whether Ms. Schneider-Heinz was ineffective in failing to identify the various problems with those convictions. Do you think at this point there is a need for an additional hearing before Judge Mim on those questions? I mean, a lot of ifs, but what do you think?
Your Honor, I don't think there would be a need for an evidentiary hearing on those. I mean, I think the records, if in case the court can't hear me, I think not. I think there would not be a need for an evidentiary hearing on those predicate convictions. I think it's clear already in the record with the PSR and so forth what those convictions actually entailed. 2 of those, of course, are cocaine convictions. We submit, Your Honors, that those were valid sentencing predicates at the time. The court had not even adopted the categorical approach in relation to making that felony drug offense determination in 2015. That didn't even come until 2018. I think Judge Ms. Schneider-Heinz could not be held responsible for anticipating the Ruth decision at that time in 2015. On the 2000 convictions, there's been references to the fact that they were not included in the 851 notice. As I believe it was Judge St. Eve pointed out, the government could have filed an amended 851 notice at any time before sentencing, which probably would have happened if Mr. Anderson had chosen to go to trial. And also, besides that fact, defense counsel testified during the remand hearing that one of the first things she did was review the criminal history provided by both the probation office and by the government, the prosecution.
But she didn't do any investigation. I mean, if she had done an investigation, the first thing she would have noticed is one of them is a misdemeanor.
True, Your Honor.
Looking at what they are and investigating are two separate things.
True, Your Honor. But part of the reason why I want to make so clear how many prior convictions there were aside from that 2009 misdemeanor, Mr. Anderson would have had to have shown that 3 of his 4 to avoid a life sentence just on the basis of his prior
Are you
convictions.
counting one from the PSR that was not in the 851? Because there were only 3 identified in the 851. One of them was a misdemeanor. One of them, the 2013 conviction, the time to appeal it hadn't expired yet, so I don't think that one can qualify. So you have 1 left in the 851.
Well, actually, Your Honor, I wanted to go ahead and mention about the one where the time to
What are
appeal
the
had
4,
expired.
if you would, please?
Certainly.
Which one am I missing?
2006, and I think the one that we need to address is the 2013, but I'll go ahead and list all of them. 2006, cocaine conviction, 2000, cannabis conviction, 2000, cocaine
So you
conviction.
are bringing in
We are
2 of
bringing
the
in-
convictions from the PSR that were not in the 851 notice.
And we're bringing in the 2013.
That was in the
heroin
851.
conviction. And Your Honor, and I see that my time has expired. Could I finish?
No, just keep talking, please.
Okay, thank you, Your Honor. I'm not sure this came up in oral argument, but in his reply, Mr. Anderson talks about the issue as to whether the state conviction there was final before he committed the federal conviction, which is what the statute, what 841 requires. We have this court's decision in the Garcia case from 1994, and that decision addressed that exact issue. The court there held that Mr. Garcia's state possession conviction that was imposed toward the end of his federal conspiracy. So the issue here is that what we have both in Garcia and in this case is a federal conspiracy. Conspiracy goes a certain length of time. And in Garcia, the federal conspiracy went from early 1990 through at least September 26, 1992. The state conviction, and as far as we can tell from Garcia, it says it became final based on when the Garcia decision says that that charge was brought. It looks like, based on the Garcia decision, that March 7, 1991 date that Garcia gives for that state conviction for possession of cocaine was simply the conviction from trial court. And then in this case, we have the federal conspiracy went from May 2010 to May 2013. The state conviction, Mr. Anderson's state conviction, occurred. He was convicted on March 25th, 2013. So just as in Garcia, the state conviction occurred during the federal conspiracy, but the federal conspiracy continued after that, the date of that state conviction. So I'll even quote one sentence if I could. The Garcia decision said, Garcia is asking this court to hold that a prior conviction should apply for purposes of the mandatory minimum only if the conspiracy commences after the conviction becomes final. And this court rejected that argument in Garcia. So yes, we do believe that the 2013 cocaine conviction also qualifies. My time has expired, of course. I could address the merits if the court has any questions on that. We believe that the district court thoroughly got that right. Judge Mims said there were 2 choices: either accept that Type C agreement for 20 years or challenge it, try to get rid of that the cause of Mr. Reeder's death. But as the district court said here, that would risk losing the 20-year sentence guarantee and exposing petitioner to a potential mandatory life sentence, even if their challenge was successful. Type C agreement, part of the purpose is to eliminate the uncertainty of sentencing. Yes, here there were uncertainties, but Mr. Anderson rationally and Ms. Schneider-Hines rationally advised him to accept that Type C agreement for 20 years to avoid all those uncertainties which could have led him to a life sentence. So we ask the court to affirm. Thank you.
Gosh, well, thank you, Mr. Simpson and Mr. Flederman. Go ahead.
Thank you, Your Honor. Just a few points. First, the Garcia case that the government mentioned is an opposite. That case, the language that the government just quoted, when the prior conviction becomes final, was a question that opinion did not deal with at all. In that case, that question didn't matter because there was a long period of time between whenever the conviction became final and the end of the federal allegations. Here, there was a very narrow window of time, and every circuit to have considered that question, even at the time that these plea negotiations were happening, came down in favor of the conviction isn't final until the window for appellate review is concluded. So there was a very meritorious argument against the 2013 conviction that Ms. Schneider-Hines failed to identify. With respect to whether there is sufficient evidence in the record that Ms. Schneider-Hines investigated the predicate offenses, I asked her point blank at the evidentiary hearing whether she investigated the criminal history. Her testimony was she doesn't remember. Judge Mim actually asked her, did you have any reason to think there was any flaw with any one of the 3 predicate offenses? She says, I don't remember, but I would have looked at the criminal history in the PSR. Even taking that as true, the PSR is too late. The PSR is after Mr. Anderson has already entered a plea deal. She conducted no external investigation. That is clear from her testimony and from her timesheets that are in the record as exhibits from the evidentiary hearing.
Let me ask you this. If we're confronted with the 2006 possession of cocaine as the single valid prior, and if we concede that there was an inadequate investigation into the Reeder death, isn't the single 2006 conviction, together with the enhancement for either Heilman or Holmes, sufficient to recognize that there would have been a life sentence potential?
It is not. That is what this court held in the last opinion. The last opinion assumed that one predicate offense would survive here and that Mr. Anderson would face a mandatory minimum of at least 20 years if he went to trial. Right. The choice he was faced with was, do you take this plea deal to 20 years or do you face certain mandatory life? The government just has to show that these predicate convictions exist and make its case that you distributed heroin and you get mandatory life. That was the choice Mr. Anderson was faced with. That is the product of inadequate investigation. And I see my time has expired. We'd ask this court to reverse.
If you have something that you feel you really need to say, just go ahead. I haven't stopped you.
Just with respect to Judge St. Eve, going back to your serious bodily injury question, and Judge Flom, yours as well. If assuming where she had investigated these predicate convictions, whether one survives or one doesn't, it's a different ballgame when we go from 3 to 1, and then we're looking at.
Is it though? If you have the serious bodily injury with it.
It is in the sense of plea negotiations, because in this plea negotiation, Mr. Anderson is faced with one of the pathways to mandatory life. The most certain and easy one from Ms. Schneider-Heinz's perspective was all the government has to do is prove 2 predicate offenses, and he distributed over 1,000 grams of heroin, and he has mandatory life. Without that pathway, it would have been unreasonable to not continue investigating the death or the serious bodily injury.
Ms. Futterman, if we could go back just a second to, I think, Judge Rovner's question. Can we be comfortable today that Mr. Anderson recognizes that success on this appeal could expose him to a much greater sentence if the government could make the case below?
I think Mr. Anderson is comfortable with that, Your Honor. That is, of course, me speaking, consulting him directly.
I mean, that's a critical question, I think, that counsel needs to be aware of in discussing, the possible ramifications of a, quote, successful appeal here.
2 quick responses with respect to the 2015 world in which we're analyzing this question.
Yeah.
It is clear from the change of plea hearing transcript and the sentencing hearing transcript that Mr. Anderson was very hesitant to agree that his conduct resulted in the death of a young man. And I think had he been presented with the choice to attack that allegation, even if it exposed him to additional prison time, I think there is substantial evidence in the record, and he's certainly shown a reasonable probability that he would have rejected the plea deal and pressed towards trial. And then for, again, practical purposes today, as we argued in the post-hearing brief on the post-convictions in the district court, we submit that Mr. Anderson would be facing the amended version of the statute under which his sentencing exposure is much less. Thank you. We ask this court to reverse.
Okay, before you leave, though, hello?
Yes, sorry.
I don't blame you for wanting to get away, but not before we thank you and your firm, Jenner, for just the truly fine advocacy that you have shown throughout the case, as well as Mr. Simpson and the government, who also has the deep thanks of the court. Thank you both so very, very much.
Thank you, Your Honor.
Thank you. All right. We'll wait till everyone leaves, and then we'll go on. Let's see. Is everyone comfortable? Yes? Okay. Then we will go on to case number 4, and that is appeal number 22-1848, Angelique Snowden versus the Illinois Department of Human Services. Hello, Mr. Baker.
Good morning, Judge Rovner, Judge Fulham, Judge St. Eve. May it please the court, my name is John Baker, and I'm here asking the court to reverse a grant of summary judgment. The Due Process Clause provides certain rights to certain governmental employees before they can be terminated. The Loudermill decision by the Supreme Court establishes this. It requires that there be both a post-deprivation proceeding where they can challenge their termination, and that there also be some type of a pre-deprivation proceeding. Now, here, we never challenged the post-deprivation proceeding. We acknowledge that it was sufficient. Ms. Snowden had a right to a grievance, which is sufficient process for a post-deprivation proceeding. However, the mere fact that there is a right, or there is a post-deprivation process, doesn't ameliorate the need for the pre-deprivation process. Now, the pre-deprivation process doesn't need to be as elaborate as what it would be for a post-deprivation proceeding. However, there must be a process. And the thing about that process is it must be meaningful. And so that term has been subject to a lot of different debate, but one of the things that this court has recognized is that in order for it to be meaningful, there must have been an impartial decision maker who was making the decision. In this case, the district court granted summary judgment, finding that Mr. Corza, number one, was primarily that he was not the ultimate decision maker. We believe that on summary judgment that is wrong, and we believe that a jury, looking at these facts, could adequately find, both that Mr. Corza was not impartial and that he, for all practical purposes, was the final decision maker.
But would you agree that Mr. Corza lacked the authority to discharge Ms. Snowden?
Yes.
Well, then why does it matter that he conducted, the investigation or, recommended her discharge before the pre-disciplinary meeting in July? He doesn't have that authority.
Well, he doesn't have that ultimate authority, but from a practical perspective, he is the one who is making the decision. Under Illinois law, it ultimately goes to the Director of Central Management Services to approve the termination. There is one individual, the Director of Central Management Services, who determines every single disciplinary action over 30-day suspension for the entire state of Illinois. No one has said that CMS, there's no evidence anywhere to suggest that CMS engaged in any sort of a meaningful review. The rules make it very clear that the recommendation is to come from the agency. And in this case, that was Department of Human Services, and it was Mr. Corza who was to make that determination.
So are you arguing that because the recommendation has to come from the agency and then it is sent to the director, that every recommendation is rubber stamped, and so they're not getting proper procedure?
I would agree with that, but I'm
not saying that's true. I'm asking you that as a question. Is your argument that because the recommendation comes from the agency, that's always rubber stamped, and so therefore everybody who has been terminated by any agency that has to get final approval by the director has been rubber stamped and none of those individuals have received proper procedural due process?
Judge St. Eve, no, I'm not making that argument. I don't disagree that CMS does ultimately rubber stamp it, and that's the part of our argument that is important.
Well, you're saying you don't disagree. I'm not saying that. It's a question. It's not a, it's not a statement.
My argument is not that CMS rubber stamps it. That's not part of my argument or our theory of our case here. What I am saying is CMS doesn't do a independent review. They get the documents, they get the recommendation. This is the director of CMS. And the problem we have is the practical realities is that you eviscerate what Loudermill means when you're talking about a very large state agency.
Why wouldn't it be sufficient for the director to sign off on or make the final decision that somebody should be terminated based on an investigation and facts that are presented to him?
That is, but the problem is the person who they are relying wholly on is the impartial person. So then Loudermill has no point. It serves no purpose because all you have to do is, if you are a large state agency, you can have anybody sit in that chair and conduct the pre-disciplinary hearing, make a recommendation. It doesn't matter if they're impartial or not, and then you just have somebody up at the top who you have no idea, who has no idea what has happened down below, who says, well, I'm impartial, I didn't have any preconceived notions.
So what's your evidence that's in the record that supports your assertion that the director here just rubber stamped the decision of a biased decision maker?
There's no evidence that the director did anything. There's no evidence. The evidence is that there is no evidence. This is summary judgment and what a jury could plausibly believe. They have offered absolutely no evidence that the director of CMS reviewed anything, that anything was presented to the director, that the director considered Snowden's statements. None of that. What we know is before the recommendation was ever made, Corza called labor relations within Department of Human Services to ensure that if it went to a grievance, that CMS would ultimately stand behind them. And he got the response that yes, that they would stand behind that. So then he said, okay, well then I'm going to recommend the termination. So what we know based on that, or at least what a jury could conclude based on that, is that there was information beforehand that Corza believed that this was going to stick. That's what he testified to. And
did you have the opportunity in discovery to depose the individuals who received Corza's recommendation and Ms. Snowden's rebuttal and who made the discharge decision? Did you have that opportunity?
I don't believe that there was ever any evidence on who ultimately made the decision. I mean, the Mr. Corza's superiors were never asked about what they reviewed? No, they were not. Ms. Wade was not discussed. There was no documentary evidence presented from her showing that she had reviewed it. She never signed an affidavit stating that she had reviewed it. There was nothing that was presented by Mr.
But what I'm asking is, in discovery, didn't you have that opportunity to depose these people and learn what happened?
Judge Rovner, I believe, and theoretically, yes, we did have the opportunity. I think I don't recall. This was a long time ago that we did the discovery in this case. I don't recall why it was that certain people were or were not deposed. But I do believe, again, the question is based on the evidence that's in the record, and there is no evidence in the record that anybody looked at anything.
But you're asking us to draw an inference that the director of the CMS is the only one with authority to do this. The information was sent to the director of CMS. The director signed and made the determination that she was going to be terminated. You're now asking us to make an inference that that wasn't enough without any evidence in the record.
Well, I think that the evidence in the record is that from beforehand, Corza was told CMS would agree and would support them when it ultimately went to a grievance. So I do think that there's evidence in the record to show that Corza at least believed that CMS was on board with this beforehand, Judge Saini. So I do understand the points that are being raised, but I think from a practical perspective, CMS is a huge state agency. The director of CMS has a multitude of responsibilities. And so by simply saying, okay, that we're going to allow the director of central management services to be the one who makes the ultimate decision, you're effectively eviscerating.
So that comes back to my earlier question. It sounds like you're arguing that it would never be sufficient.
No, I don't believe that, because it would require, in order for it not to be sufficient, it would require a fair decision maker. Most of the time, when there is a person in Corza's shoes, they are fair. Most of 99% of the time, they are fair. So no, I wouldn't argue that every time it's unfair. The idea is the person who is sitting there, reviewing it, making the decision, from all practical purposes, making the recommendation, they have to be fair. And so that is what I'm arguing, that Corza himself was not fair in this situation. I see my time has expired, but that is our view. Thank you.
Thank you. And I will give you a minute or two for rebuttal, of course. Hello, Ms. Gottlieb.
Good morning. May it please the court. I am Assistant Attorney General Anna Gottlieb for Defendants Appellees. Plaintiff challenges the process she received after an investigation revealed that she falsified records to the detriment of nearly 24 Social Security disability benefits recipients. This court should affirm summary judgment on the due process claim against Mr. Corza, which is the only claim pursued on appeal, for 3 reasons. First, no reasonable jury could find that plaintiff did not receive sufficient pre-deprivation process where she was presented with the charges, on multiple occasions and given an opportunity to present a rebuttal. Second, the plaintiff also had post-deprivation process available to her through the grievance process and the collective bargaining agreement. She took full advantage of that process, further providing an additional safeguard. And as counsel just noted, this process was never challenged. The adequacy of that process was not challenged before the district court or here on appeal. And third, Mr. Corza is at a minimum entitled to qualified immunity to the extent there is a question about whether his conduct could have amounted to a due process violation. The law was not clearly established to show that an individual could not make a recommendation after an investigation, but before considering the rebuttal in a case, particularly where, like here, there was sufficient post-deprivation process and others were involved in the decision-making process. In response to the notion that Mr. Corza was a biased decision maker, there is no evidence of that in this record. Rather, there is evidence to the contrary. As an initial matter, the Supreme Court has noted that decision makers are presumed to act with integrity and honesty. The Supreme Court has also told us that to overcome that presumption, there needs to be a showing of pecuniary interest or some sort of personal bias. And this court has referred to actual prejudgment of a case, but in Wallace v. Tilley, this court has also set the bar for that standard to be very high by noting that an individual must have definitely made up their mind before considering a hearing or any kind of rebuttal. Mr. Corza's actions don't fit any of these. He testified that at the time of the pre-deprivation meeting, he had not made up his mind about the discipline because it, quote, depended on what was going to be in the rebuttal. There's no evidence contradicting the statement. And in fact, there's a summary of the pre-deprivation meeting that also notes that discipline was undetermined at that time. And separately, Mr. Corza was not the one ultimately responsible for the decision-making here. Rather, pursuant to statute, the Illinois Central Management Services is the only agency that could have made the decision to terminate. After consultation...
We know that Mr. Corza passed along Ms. Snowden's rebuttal along with his comment that it didn't change his mind. But does the record affirmatively reflect that one or more of his superiors reviewed the rebuttal, made an independent evaluation of the rebuttal?
We don't have evidence about who considered the rebuttal, but we do have evidence about the discussions that took place before, after Mr. Corza made the initial determination. There's an email that reflects that the recommendation, which was sent to Quinetta Wade, was discussed with someone else in the in the IDHS Labor Bureau, and that was eventually discussed with CMS. As for the rebuttal itself, we don't have particular evidence who considered it after Mr. Corza passed it on, but he did testify that he did pass it on. And also, with regard to the rebuttal, there's nothing in the rebuttal that specifically addressed the charges made against Ms. Snowden. Rather, there was just a notion that mistakes were made that don't really rebut the actual charges presented there.
Okay.
But to the extent there is any question about the pre-deprivation process here, there's two separate issues that also provide independent bases for affirming summary judgment. The first one, again, is the post-deprivation process. That was never challenged, and this court in Wallace v. Tilley also noted that even if there is some existence of prejudice in the pre-deprivation phase, the existence of post-deprivation process can take away any of that prejudice. And this court has held in Winston and Butita that the grievance process set out by a collective bargaining agreement is sufficient to meet due process. And separately, as noted, to the extent there is any question about the conduct here, qualified immunity would also protect Mr. Corza because there are no cases that specifically talk about providing a recommendation before a hearing or before a rebuttal is considered. And in fact, logically, that is just standard practice in many employment contexts where an individual must make a determination about whether the charges would warrant a particular type of discipline if proven. The cases relied on by plaintiff for this point do not provide the law with sufficient particularity that would have put the defendants on notice that this was a due process violation. So for these reasons, if there are no further questions, we ask this court to affirm. Thank you very much.
Thank you very much, Ms. Gottlieb. Mr. Baker, you used your time, but we'll give you the 2 minutes. Go ahead.
Thank you for your indulgence, Judge Rovner. I do greatly appreciate it. I want to address a couple of points. Number one, this idea that there was that there's no evidence that Corza was not impartial. I mean, it's there's never going to be a case where there's more evidence. You know, here we have the CMS person, or excuse me, the labor relations person telling her, you schedule a pre-D meeting and lay it out with her. We'll give her the 5 days to rebut anything, and then we will put her on the suspension pending discharge. I mean, that's basically saying, hey, yeah, go ahead and have the hearing. We've already decided what we're going to do. That's what we're going to do. He then makes the recommendation, which is very clear that he is recommending termination. He knows that, so he knew that. This is not somebody who is impartial. He has made up his mind already. That's evidence. And again, we're talking about, could a jury look at that and make that conclusion based upon this evidence?
Mr. Baker, did you raise this argument in the district court?
I'm sorry, which argument?
Did you raise this argument about Corza?
Yes.
In the district court?
Yes.
So you didn't waive this?
The Corza argument?
Yeah.
No, there's a reference in their brief about waiver, I think, that talks about the fact that we didn't specifically cite to the CMS rule that talks. So I think that was their argument on waiver. But as far as addressing the Corza issue, that was addressed before the district court. So we have that. I want to talk a little bit, only at 20 seconds, the qualified immunity. This court has made it clear that the decision maker must be impartial. Corza knew that. Any reasonable decision maker would know that. I see that my time is expiring again. I thank the court for its indulgence, and we would ask that the court reverse and remand this matter for trial. Thank you.
Thank you very much. Thanks to both Ms. Gottlieb and Mr. Baker. And case is taken under advisement. All right. Okay. All right. Appeal number 22-1808, United States versus Jorge Leal. Hello, Ms. Christensen.
Good afternoon, Your Honors. May it please the court, counsel. My name is Joanna Christensen. I represent the appellant Jorge Leal. The district court plainly erred in this case by giving both an entrapment instruction and an instruction instructing the jury about the deceptive techniques of the government. The jury was confused and misled. I'm sorry? Oh. And Mr. Leal was prejudiced by this decision. We recognize that we have waived this issue in front of the district court, but are relying on this court's more recent cases holding that waiver in such a situation would be a very harsh punishment on Mr. Leal.
Ms. Christensen, I have some questions along that line because
Sure.
Our case law is not exactly crystal clear on whether or not a no objection waives or forfeits an issue. We have, quite honestly, case law on both sides saying it. Where do you think the line should be drawn on when something is waived versus forfeited when we can review it for plain error?
Well,
on jury instructions.
Right. I agree. The case law is not exactly clear, and I think that my understanding from reading it and kind of trying to come to a rule is that it is a waiver. I think it's a classic waiver saying no objection. But in the interest of justice, this court will review for plain error despite the waiver. I
guess the question is, should that be a waiver? Should no objection be a waiver? I think we may be the only circuit that has held that.
I think so. As far as I know, I certainly think so because of the situation we have here.
You think no objection should be a waiver as opposed to a forfeited?
Well, I think technically it's a waiver, but I think it should still be reviewed for plain error, which also straddles the line of language that we don't use together.
Right. If you
Right.
waive, you waive.
Right. I mean, I would hate to muddy the waters of forfeiture in that way, but I think that there should be some exceptions to waiver, and maybe that's what my argument is essentially, is that there's an exception here.
We recently, and I know this may be unfair because it wasn't briefed, so if you're not prepared to answer it, that's fine.
Okay.
We recently suggested in the U.S. versus Gann decision that Rule 30 of the Federal Rules of Criminal Procedure requires all jury instructions that are not objected to at the district court to be reviewed for plain error. Do you agree with that? And again, I realize it wasn't briefed, and it's fine to say you're not prepared to address that.
I think I did read the Gann decision.
It was in a footnote.
Right. I don't think that's unfair, because I think that in general, if there's no objection, that's forfeiture and then plain error. So I think that is in line with the forfeiture plain error rules. As far as all, I think that there are going to be exceptions, and I think, like in this case, there are going to be. But
our general forfeiture waiver distinction in the criminal context comes when we can tell there's been a strategic decision not to object to something.
Yes.
Is there a way to make that determination with a no objection?
It's tough. And it's tough because these direct appeals are based on the record as it exists. So, and I know that, and
here something took place off the record, so we can't, with the law clerk, we can't tell exactly what happened.
And I do have, obviously, as an appellate attorney, I have concerns about what takes place off the record, but my job is very limited to the record.
Correct.
There's a case that, unfortunately, I haven't cited. I know that I'm not supposed to talk about it, but it's an older, maybe 20 years ago, Jaime case, where there was an agreement to a guideline, and there was no objection. And this court held that they couldn't see a reason not to object to this because it was a clear error in the guidelines. And I'd be happy to file that with the court. And I think that that's what we have to go on here, is that if there's no reason that we can discern, then a defense attorney would fail to object to this, aside from negligence and just, the heat of trial as it is in this case. I think that that's as far as we can go.
Although the jury instructions don't necessarily fall within the normal heat of trial context, because they're done either before or at some point when you don't have the jury in and all the other craziness of trial is going on.
I think so. I think in this case, because you have this entrapment issue, and the decision on entrapment wasn't made until after all the evidence came in. And then it's a ruling by the district court. Toward the end, we're preparing for closing arguments. I can see where it just slipped through the cracks for defense counsel. And fairly for the district court and the government too. It was actually printed on the jury instruction that the court filed, that they should consider this deceptive techniques, how it influences an entrapment decision by the court. So I would agree this court has kind of gone back and forth, but I come back to that this is the type of case where an exception would be warranted.
How could it be plain error if it's in the commentary to a jury instruction and a suggestion?
Right. A suggestion, I think it's almost akin to a footnote in an opinion, except it's not a written opinion. But the court's...
Well, it's different because, jury instructions, the pattern instructions are just guidelines. They haven't been...
Sure. Right.
Blessed in any kind of opinion by the court.
But certainly I think this court and the instructions committee expects for parties to rely on and will often affirm if an instruction comes directly from the pattern instructions. And I think it's appropriate guidance. It's not just that footnote to the instruction. It's also that this court, in McKnight said, we have some concerns about this instruction. I think the Eighth Circuit took that even further in Struberg with because that was an entrapment case, and said, this has got some real concerns. This deceptive practices instruction cuts right through inducement. And that's one of the elements now if the entrapment instruction is given.
I come back to plain error. And if the commentary had said, you should give this if you give instruction, or something more definitive, even then it's commentary. I think there's a challenge. But given that it's just a suggestion, how could that be plain error?
I think it's plain error when it prejudices the defendant. That the error is there, the instruction has noted that there's this problem with giving both instructions, and it asked the court to make the consideration. And my argument is not necessarily, although in this case I don't think the entire instruction should have been given, but I think it could have been amended as well in other cases to cut out part of it that says the government may do this so as not to undercut the inducement portion of the entrapment issue.
But in this case, it just seems to me that the possibility of giving instruction 3.19, had been present from the start of the trial. In other words, I'm trying to figure out why you think the defense was not on ample notice of the need to modify that instruction if and when the court decided to instruct the jury on entrapment.
I think,
even though I take your point that it wasn't until late, I get, in the case that Judge Gilbert decided to instruct the jury on entrapment.
Sure, I think defense counsel was on notice, and we can assume that defense counsel was on notice, as well as the district court and the government were on notice, I hope, who are all familiar. And we're in this situation because defense counsel didn't make an objection. And that goes toward the negligence. I think failing to make that objection when someone is on notice would go toward showing negligence in this case, which would lead us to the exception to the waiver. So I see are there other questions? I'm almost out of time completely, but I'll save some time.
I'm going to give you your...
I do. I've been here all morning, so I'll reserve those minutes. Thank you.
That's the problem. I shouldn't give it to case 1, 2, 3, and 4. All right, go ahead. We're going to Mr. Leggins.
Good afternoon, Your Honors. My name is Tom Leggins, and I represented the United States below during the trial of this matter, and I'm here on appeal for the appeal today.
I have a question that I'd like to get off my mind, if you don't mind. And it's this. If the jury, in assessing entrapment, was considering Corey's remarks about being a big boy who could make his own decisions and knew what he wanted, might the unmodified language of instruction 3.19 have caused the jury to think that remarks along those lines were perfectly fine for an undercover agent to make and were not evidence of inducement?
I think, Your Honor, that's speculative.
But I'm the one speculating. Can you help me with?
I guess where I was going is you can speculate the other way, as I point out in my brief, that those two instructions can be considered in conjunction as saying deceptive investigation techniques are okay so long as you don't entrap someone, as was explained further in the instructions. To the extent I think that is my answer to your question, if that's satisfactory. Getting to the question of the case law and what happened in this case and where the line should be
Yeah,
drawn.
I was going to ask you the same series of questions.
Where should the line be drawn?
Do you agree that there are case law is not crystal clear on that? You can find some cases saying no objection is a waiver, or in some cases saying no objection is forfeited.
You know, and it's kind of, I don't know that I don't think I found a case where this court has reversed on the principle.
Well, that's a separate question, if we've reversed or not, rather than the standard of review.
And I think the standard of review in this case is waiver, and I think where should you draw the line? From my reading of the cases, is that when an attorney says no objection and there's evidence in the record that he really meant it. And there is evidence in the record.
And how do we determine whether they really meant it?
Well,
or whether it was, by that I think you mean, was it a strategic decision?
I don't even know that it has to be a strategic decision. I mean in the sense that you have to delve into the mental state of the defense attorney. We presume that counsel is competent. And I believe in the record in this case, the notion that this was an off-the-cuff, no objection uttered during a rote call jury instruction conference is undermined by the record in this case. And the record in this case is, even without the materials I tried to supplement, the record in this case is clear that the parties took the instruction seriously in this case. The judge issued an order, his standard pretrial order, and that's in the record at document 103, instructing the parties to confer before trial. The day after that, which was about 11 or 12 days before trial, I filed a 19-page jury instruction memo, which included all the instructions I intended to present for consideration at trial, and an analysis of the ones that I thought might be legally fraught. The parties then had our conference as the court directed, and that is reflected in the defense jury instruction memorandum at, I believe that's in the record at 105. That was an 11-page memorandum where the attorney raised objections to some of the remaining of the government submitted instructions, and thereafter the court then decided the entrapment issue at the defense's request during the middle of trial. Nowhere in any of these discussions did the defendant indicate that he had any objection to Government's Exhibit 4, which is what I refer in my brief.
Are you familiar with the court's opinion in U.S. v. Gann, where it was suggested that Rule 30 requires all no objections on jury instructions to be reviewed for plain error?
I was not familiar with that. I would still, even in light of that, I would persist that in this case there is an abundant amount of information in the record to indicate that this no objection was not announced in the context of a rote call jury instruction conference.
Gann didn't take that into consideration, though. The suggestion in Gann, and it was just a suggestion and a footnote, was that regardless of the reasons why, if it's a no objection, it should always be reviewed for plain error.
And I can tell you, just as someone who tries cases on a regular basis, one of the problems I have with that is sometimes terseness and brevity, like no objection, is because you've done all the preparation beforehand for that jury instruction conference, because nobody wants the jury waiting. The court doesn't want the jury waiting, and that's why the formal jury instruction conference tends to be no objection or objection, and it's because the parties have put the time in beforehand, which we did. So I think I would counsel, if you're asking me my opinion on Gann and what you've described as the footnote, I think it's a bad idea, because the district judges know how they want to handle these things. They issue pretrial orders saying, I want you guys to get together and discuss these. I want these things worked out. I want a very quick formal jury instruction conference for good reasons. And if you layer in this notion that just announcing no objection isn't sufficient, you're necessarily going to prolong a process that everybody's working to constrict.
So you're saying that you all, in this case, had gotten together before the conference?
Oh, sure. And
Okay.
we had gotten together, and that's referenced in the jury instruction memorandum that the defense counsel filed in footnote 1. He references the conference we had, and that conference was in response to the judge's order to have that conference, and it was in response to my having filed my jury instruction memorandum with all of the attached instructions. So again, getting back to where do we draw the line, I think it goes back to when they said no objection, did they mean it? That's a good place to draw the line. I think
That can be hard to tell sometimes from a record.
I
Maybe not in this case, but that can be hard sometimes.
I agree with that. I do have confidence in the judges in our district that they pretty much endeavor to have the parties confer, have the parties make some legitimate. We may obviously I need to do a better job of making a record of what happened, perhaps, but I think there's enough in the record here. I think. We have the kind of the fountainhead of this whole notion that no objection might be an exception is in the Natale case, which we have the author of that on the panel, and I mean he could tell us better than I can, but I believe the import of that case is we just want to make sure that when they say no objection, they mean no objection, and. In this case, and I'm not concerned about any cases in the future, but for the purposes of this case, I think it's clear that the no objection was considered. It was deliberate. It's something that the parties spent a great deal of time on jury instructions in this case, and I see I only have 40 seconds left, so I will just say that I agree with Your Honor that to the extent that the provisions in the committee notes are just a suggestion, that cannot rise to plain error by itself. And if there are no further questions, I will yield the rest of my time.
Thank you. Thank you.
Ms. Christensen,
Yes.
is it your position that pattern instruction 3.19 should never be given in an entrapment case?
No, that's definitely not my position, because I think it does have a place. The government is allowed to do the things that they did, some of the things. The question is, how far does it go toward cutting out an inducement inquiry by the jury? And there's a statement, I didn't bring it up, but the second sentence of the instruction is the government's allowed to do this. And perhaps cutting that out might balance the inducement and deceptive techniques instructions.
So what would you cut out?
The second sentence where it says the government is allowed, now I can't remember exactly. It's in a footnote in my reply brief, which I of course didn't bring with me up to the bench. But I would cut that second sentence out, and perhaps the rest of it then would be.
Do you want to get it? Because I'm giving you 2 more minutes.
I think it reads the government is permitted to use these techniques.
Yes, that's it. Thank you, Your Honor. Yeah, it's on page 8. And that the government is permitted to use these techniques, because I think that's the part of the instruction that tells the jury this is okay. What the government did here is okay. And when you look at that in conjunction with inducement, where the government's got to argue that they did not induce or prove that they did not induce, they can just fall back and rely on that, but everything we do is okay. So without that sentence. Now, in this case, I think it would have been, this case is not a slam dunk evidence-wise, certainly in comparison to some of the enticement cases. In this case, I'm not sure it's appropriate at all.
In this case, what?
I don't think that the instruction on deceptive techniques was appropriate at all, but my argument is that the district court should have made that analysis. So unless the court has further questions, I will ask this court to reverse and remand. Thank you.
Thank you.
And we thank you, Ms. Christensen, and we thank Mr. Leggins, and we hope you have a good trip home.
Thank you.
Thank you. All right, my goodness, we're coming to the last case of the day, and that is Appeal number 22-1820, Rene Martinez versus Kilolo Kijakazi, and Ms. Fisher will wait for Ms. Fisher. Hello, Ms. Fisher.
Good morning, Your Honors. May it please the court. My name is Jennifer Fisher, and I represent the plaintiff, Rene Martinez. This case is about legal error. The ALJ made a series of legal errors in deciding Mr. Martinez's claim for supplemental security income benefits, and Social Security's Appeals Council compounded those errors when it failed to produce a complete transcript and administrative record, which was necessary to permit the district court to engage in meaningful judicial review of the commissioner's denial of benefits. It's important to understand that this case is not a case where historical facts were unclear or materially disputed. Mr. Martinez is a man who was over 50 at the time he filed his application for SSI in November of 2017. He had little work history. He had not earned more than a few $100s in any month since he had filed for benefits. He was diagnosed with and treated for COPD and asthma, depression, and anxiety, among other medically determinable impairments. He went to the doctors and he underwent treatment, the treatments that his doctors recommended. The only real dispute is whether Mr. Martinez's medical conditions caused the functional limitations that prevented him from working at a substantially gainful level. That is, whether he was disabled as defined in the Social Security Act. That is a legal question.
Could you please address the ALJ's point that the doctors, Pansner, did not tie what they believed to be Mr. Martinez's psychiatric limitations to specific functional limitations?
Yes. The ALJ, okay, that's part of my legal error point, is when the ALJ discussed that medical opinion, which was a joint opinion offered by two doctors whose last name is Pansner, a psychologist and a psychiatrist who worked together to treat Mr. Martinez. The ALJ talked about a number of factors that led her to conclude that the opinion was not persuasive and not supported. But the regulations say that the most important things to look at when evaluating a medical opinion are consistency and supportability. And so going back to your question, what the ALJ did was she decided that the opinion wasn't consistent with her findings about Mr. Martinez and his disability. So she went in then and she said, well, I don't like the language that was used in this case. It's not specific to functioning. But in fact, it was in some respects consistent with functioning. Let me flip over here to the opinion. And so, for example, they gave specific examples about his ability to maintain attention. They gave examples about anxiety. They gave examples about his ability to maintain employment, and that turns out to be one of the main factors that prevent people from being able to work, is whether or not they can make it to work every day. And that comes out in the vocational testimony, is if you miss a day or two of work every month, most employers won't keep you around. So when they talk about those specific work-related functions, maybe it's not how much he can lift or whether he can sustain attention for 2 hours, but being able to make it to work every day turns out to be a really important work-related function, and that is addressed in their opinion. And so that's a legal error that the ALJ committed, because instead of looking at consistency, supportability, she looked at factors that were not pertinent under the regulation. And then instead of taking into account the actual functional limitations, she essentially nitpicked the way they were set forth. So she said, I don't like the way the doctor described these limitations, so I'm not going to consider them. But that's not what the regulations say. The regulations don't say you can disregard a functional limitation if you don't like the way the doctor described it. What the regulations do say, or give the ALJ the discretion to do, is if the ALJ doesn't think that it's a particularly relevant way of describing it, the ALJ can contact the doctor and ask for clarification. That the regulations provide for that. And that makes a lot of sense, that if it's not useful, then get clarification. And she didn't do that either. Instead, she just said no. And she didn't use the right rules to do that. And so that is legal error. And the government, in response, has asked the district court and asked this court to ignore the legal error and instead say, there's a scintilla of evidence that supports her factual findings, because she said a few things that are, arguably factually true about his opinion, the opinion about his functioning. And under a substantial evidence review, you'd have to give that finding a lot of deference. But if you review for legal error, you don't have to give that deference. Because if you review for legal error, then you look at whether or not the ALJ followed the rule. That is not entitled to deference. If you review for substantial evidence, then you have to look only to see if there's a scintilla of evidence supporting a factual finding. There's not a question here about whether or not Mr. Martinez saw the doctors in question, whether or not their findings are supported by treatment. No one is saying that they didn't treat him. No one is saying that the treatment wasn't appropriate. No one is saying he lied to them about his symptoms. So those are not factual issues that needed to be resolved. The issue is whether the ALJ followed the rules in evaluating their opinion. And we are saying she did not follow the rules, and we're asking you to insist that she does. Likewise, we're asking you to insist that the case be decided only based on Mr. Martinez's records, because the ALJ said that she carefully reviewed the case and made a decision after finding that Mr. Martinez made a series of inconsistent statements about his symptoms and limitations, which is within her purview. She can find that he made inconsistent statements, but if she's going to do that, again, she needs to follow the rules, which she did not do.
Ms. Fisher, have you ever seen B15F? I think that's the exhibit. The exhibit?
I have not.
Okay. So throughout I know it's not in the record, and I know you didn't have a copy of it, but did you ever see it through the course?
I have never seen it. Okay. I don't know what was in it, other than as it was described in the ALJ's decision.
Did Ms. Martinez ever see it, to your knowledge?
I don't believe he ever saw it. I don't know.
You don't know if he did
I just
or not.
don't know.
Okay.
What I do know is that the ALJ described 9 pages of records in one sentence. Now, we often say ALJs don't have to describe every piece of evidence in the decision, so it's not unreasonable to assume there's more in that evidence than was described in the decision. We just don't know what was in there, and that's the problem. Because she said that she didn't believe everything he said because his statements were inconsistent. And then she said, here's what this doctor said about his treatment, and here's what his statements are. Of course they're inconsistent. That's not what happened to him. So what he said about it is not going to match. That's inconsistent. So how can that be harmless error? That's not harmless. You can't have your case decided on somebody else's records and have that be harmless. It's just, it's mind-blowing to me, honestly, that it has come this far. But it's not unusual, frankly, for other people's evidence to be incorporated into an administrative record. And that's why the Social Security Administration has rules about what to do in that situation. Unfortunately, the rules were not followed in this case. I don't know why, but they weren't. So what we're asking, again, is just to have Social Security follow their own rules, take the evidence out, and give Mr. Martinez a full and fair hearing based on the evidence in his case.
Okay.
And I think your time is up.
Yeah, I will give you some rebuttal time, but yeah.
Thank you.
Thank you. All right. Mr. Hensley. Hi, Mr. Hensley.
Good afternoon, Your Honors. May it please the Court, I'm Jay Hinesley, and I represent the acting commissioner in this case. Yes.
May I start you out, please? Because with respect to the joint opinion of the doctors Panzer, even if we set aside the portion of their opinion addressing non-psychiatric issues, it seems to me that they identified substantial concerns about Mr. Martinez's ability to hold a job in view of his mental health conditions. Yet, the way I saw it is that the ALJ brushed that off altogether. I take her point that they did not attempt to identify specific functional limitations resulting from his psychiatric difficulties. But aren't the limitations obvious, particularly when we combine their opinion with the pessimism that Dr. Pradina herself expressed about Mr. Martinez's job prospects?
Your Honor, with regard to both Drs. Panzner and Dr. Pradina, functional limitations, quite frankly, are what the ALJ has to work with. If there are no functional limitations expressed, specific functional limitations, then there's, quite frankly, nothing to incorporate into a residual functional capacity assessment and a corresponding hypothetical to the VE. Here, not only do we have an absence of actual functional limitations with regard to Drs. Panzner, there's also a great sparsity of evidence supporting mental limitations. I would like to point out to the Court, the number 9 is not only associated with the pages from another claimant, the number 9 also is associated with the total number of pages in this record showing mental health treatment. They're spread out between Exhibits 3F, 12F, and 15F, but they amount to 9 pages of mental health treatment, none of which speak to significantly abnormal mental findings. They're mostly speaking towards medication adjustments. They're just treatment notes that are, quite frankly, not particularly significant. The ALJ noted this, appropriately noted the doctor's opinions were inconsistent with the evidentiary record, including the findings of Dr. Pradina. And going to Dr. Pradina, again, the observations from Dr. Pradina were general. Dr. Pradina said that Mr. Martinez's ability to sustain concentration and persistence appeared to be impaired, and he would likely have some problems and would likely struggle to get along with supervisors and coworkers. But Dr. Perdina also said, expressed the opinion that he would retain the ability to go back and perform some of the past work that he had done in the past.
I have to tell you, I'm trying very hard to have an open mind, but I felt that the ALJ used this consistency terminology so frequently throughout her opinion that it gave rise to questions as to whether she really understood what Mr. Martinez's burden was in claiming to be disabled, and whether she was simply saying that certain of his alleged limitations were not credible in view of the objective medical evidence, or she was saying more broadly, okay, that he was not credible as a claimant, or that his overall case was not credible. And when she keeps using these phrases like not entirely consistent or entirely consistent, it really started to make me wonder whether she was holding him to an inappropriately demanding burden of credibility. And I really have some concerns about oversights on her part.
Your Honor, I'm sorry.
Yeah.
The ALJ's use of the word inconsistent, I really don't take it to mean incredible, lacking credibility. I think she was giving a fair assessment of whether his statements of disability were supported by the overall evidence of record, not just the objective evidence, but the overall evidence of the record, his daily activities, the type of treatment he received, his improvement with treatment.
Well, that raises another problem. I'm concerned about the missing documents,
okay.
B15F. And I agree with you that she said this was consistent or inconsistent with the overall record. How can we even review it when she relied on an exhibit that isn't in the record that reflects medical records of somebody else?
That's a fair concern, Your Honor. My response to that is that if you look at her very little references to this.
I did look at this, and I know you said 2. I counted 7 references to B15.7. And I include in there references where she says, talks about what those documents reflect or don't reflect. The medical records do not show that his claims of headaches and other things significantly impaired the sustained work function. How could we make that determination without knowing what's in those records? So in other words, if she's relying on records of another claimant whose conditions are not as severe as Mr. Martinez's, I think even you would agree that's error.
I think what we need to look at is for what purpose did the ALJ look at these records? It was for 2 reasons. One, does Mr. Martinez or does he not have additional severe impairments that the ALJ, need to consider? And 2, is there evidence in these additional records that I admittedly should not be looking at, but they're in front of me and I'm just not realizing that they're someone else's? Does this show additional functional limitations that I need to incorporate?
But how can
you
say that? Because I don't think it's clear from the record that she was looking at the records to see if there were any additional limitations. Some of this could be interpreted that because the records don't reflect the severity that is before the court on Mr. Martinez, that she's discrediting what he has said.
I really don't think that's the case, Your Honor.
But how can we decide that given that we don't have the records?
If I may, and I in my head, I came up with 3 hypotheticals that I think would be very different. If the LJ had referred to something prejudicial to Mr. Martinez, this is the first one, in connection with this other individual's records. Like, say, for example, she said, the Dr. So-and-so mentioned that he'd recently been walking a lot or rock climbing or bowling or something like that. There's nothing like that in there. Secondly, if the ALJ relied on the other claimant's records to show significant improvement in Mr. Martinez's condition.
Well, isn't that first example that I gave just the flip of that? Because she relies, or she cites the record to say that the medical records do not show that Martinez's claims of headaches, and then she gives a list of his claims, significantly impair or limit the sustained work function.
But these are speaking to impairments that Mr. Martinez does not even claim to have. The cases cited by Mr. Martinez in the reply brief, Hill and Hargrove. Hill, I'll give a Westlaw cite on that. It's 2021 Westlaw 2430938. In that case, the ALJ meaningfully relied upon another patient's records to conclude that the limitations attributable to plaintiff's mental health symptoms were not as severe as alleged. That in that case, the district court actually noted that the erroneous records actually weakened support for the ALJ's non-disability finding, and the court was unable to discern whether the same conclusion would have been reached. I don't think that's the case here. The ALJ was trying to determine... How can we
decide, though, without seeing what's in the records? I mean, she made a determination that these records don't support the severity of what he's claiming.
I would rely on what the district court in this case did.
But the district court didn't see the records either.
They didn't, but the district court noted correctly that had it been different, had he been given credit, if you will, for an additional impairment, he only would have stood to benefit. He would have had additional limitations that would have had to have been incorporated into the residual
But if
functional
he has
capacity.
limitations and the records were relied on for the fact that he doesn't, how is that not error?
If he has
these impairments and the ALJ discounted them
because
of what's in the records of another claimant, how is that not error?
Because here the records from the other claimant pertain to impairments that Mr. Martinez doesn't even claim to have, and there's no evidence. These were in a.
I think we're in Alice in Wonderland. I really do. Look, the ALJ was contrasting findings of this Dr. Goebel and this other claimant with those of an agency consultant, Dr. Parker. I mean, I'm sorry, but that's the
bottom line here, and I know I'm well past my time. If I may just close, I would say that if substantial evidence supports the ALJ's decision, then whether any of us would have done things differently is not relevant.
But my point is, how do we know if substantial evidence supports her decision when we don't know what some of that evidence is that she cited 7 different times in her opinion?
And again, Your Honor, I would just say that because these are chiropractic records, and Mr. Martinez's impairments have nothing to do with chiropractic. Now, the best case scenario...
You'd be surprised at what chiropractors treat, actually.
But his impairments are COPD and asthma, obesity, and mental impairments. And I realize I'm taking up the court's time, but I appreciate your time. Thank you.
No. Are you done? Yes, I guess. Is there anything you really wanted to add? I'll give you a minute.
I believe I've said everything that
okay.
Said. I appreciate it.
No, thank you. Okay. Ms. Fisher? Yes. I'm going to give you 2 minutes.
Thank you. All right. I will just briefly address the point about the brevity of treatment records. It's important. Mr. Martinez had an SSI claim, which means they only started looking at his treatment records around the time he filed this application. there's a note that says he had been treating with both of the Drs. Pansner beginning in 2015. There's also some evidence showing that he had filed previous applications. So I think that looking just at, the SSI application itself indicates that he probably didn't have a lot of financial means. So I think there's a lot of reasons besides, his mental health wasn't that bad, that could explain not a lot of records. And in any event, he did get regular and ongoing mental health treatment. All of the doctors who saw him believed he had very serious mental health conditions. The ALJ found he had mental health conditions that were serious, caused work-related limitations. I mean, I don't think that that is an issue that is really, there's any real question about whether or not his mental health conditions were serious. I think that to the extent the ALJ raises that, it's not, it's kind of a laundry list sort of issue. What I would like to devote more of my time to is an issue that you raised, Your Honor, and that is the ALJ's seemingly confounding of this credibility analysis or this inconsistency of statements with Mr. Martinez's burden of proof. There's a burden of proof, the preponderance of the evidence that's required to find a person disabled. That's different than this consistency of statements that they look for to credit what a person says about their own symptoms and limitations. There's different regulatory schemes for evaluating symptoms and limitations as opposed to the overall finding of disability. There's a lot more leeway and discretion that an ALJ has in evaluating subjective statements about your symptoms and limitations, and that makes a lot of sense. But when it comes to the overall legal conclusion about whether or not somebody is disabled, that is a legal finding that has to be based on a preponderance of the evidence. And as you pointed out, in this case, it looks like the ALJ kind of strayed from that finding, that legal finding based on preponderance of the evidence to it's consistent, it's not consistent, and just use that as kind of a proxy in a way that's not consistent with the rules. And again, all we're really asking for at the end of the day is for Social Security to follow their own rules, to look at evidence that it only belongs to Mr. Martinez, to consider the medical opinions under the rules, and to base the decision on a preponderance of the evidence under the rules. And if there's no other questions, thank you very much. We ask that you remand this case.
Thank you very much. Case will be taken under advisement.
Thank you.
Thank you to Ms. Fisher, and thank you to Mr. Hinesley very much. And the court is in recess until Monday morning. Thank you.